Good evening, everyone. We are on the record. Today is Monday, the 12th day of April, 2026. This is a regular meeting of the Rent Protection Special Investigation Committee. We had a scheduled 5 p.m. start, and the clock on my cell phone is showing 5:06 p.m. May we have a roll call for the commencement of this meeting? Councilman Zupa,
Present.
Councilman Efros,
Present.
Councilwoman Little,
Present.
Councilman Gilmore is on the way, Councilwoman Singh,
Present.
Councilman Griffin, Councilman Navarro.
Here.
Okay. So we have 4 council members in attendance. Oh, I'm sorry. We have 5 council members in attendance at 5:07 p.m. Can we kindly rise for a salute of the flag? Thank you very much. On behalf of the members of the Rent Protection Special Investigation Committee, in accordance with the New Jersey Public Laws of 1975, Chapter 231, the Open Public Meetings Act, also known as the Sunshine Law, adequate notice of this meeting has been provided by posting on the bulletin board of the first floor of the City Hall. In addition, at the time of its preparation, the notice of this meeting was similarly disseminated on Thursday, April 9th, 2026 at 4:34 p.m. to the mayor, municipal council, business administrator, corporation council, and the local newspapers and posted on the city's website. So I can certify as to our total compliance with the Sunshine Law. At this time, I'll turn it over to Councilperson Little.
All right. Thank you so much for being here today. I'm acting as chair for the moment. Our chair, Councilman Frank Gilmore, is on his way. And when he gets here, I will let him sit in the hot seat here. But I want to thank Director Chiron Richardson and the staff of the Division of Housing Preservation for attending today and being willing to answer our questions. I appreciate being able to have an open and genuine dialogue with you. So just, are those microphones, you prefer to answer the questions sitting or you prefer to go up to the podium? It's up to you.
They rather sit, so that's why I set up the mics for them. And if you wouldn't mind, Councilperson Little, if they can identify themselves for the record, and you can start with.
Good morning, Madam Chairwoman. My name is Jim Carroll. I'm the president of the Jersey City Management Association. I'm here today.
Take it off there.
Yep, I'm okay. Good evening, Councilperson Little. I am Jim Carroll. I'm the president of the Jersey City Management Association, and I'm here today representing my members, Director Chiron Richardson, Director Eric Bulworth, and John Noel.
Who is the third person, David?
John Noel.
Good evening, Council. Director Chiron Richardson from the Division of Housing Preservation.
Yes, good evening. Michael Bukowski. I'm an attorney on behalf of the association, as well as derivatively the unit members that you called to question today.
I'm sorry, would you just repeat your title again? You're an attorney on which litigation?
I am the attorney for the Jersey City Management Association. The individuals that you called to testify today are members of that association. So I'm here on behalf of the union and derivatively on behalf of those unit members.
Understood, thank you.
Do we have any other introductions? Or the other folks here are not planning to testify, or?
Sorry, my name is Jonna Noel, just in case any questions need to be assisted with. I am the manager for the Office of Landlord Tenant Relations.
Thank you.
Good evening. Good evening, council people and Council Commissioner Little. My name is Eric Bolwith. I'm the Assistant Director for Division of Housing Preservation.
Okay, thank you. Just wanted to get everyone's names in the record. I appreciate that. So I guess with that being said, I think we will open it up to questions if that's all right.
Sure. Not sure if we have kind of structure of how we want to ask questions or what our timeline is for this meeting today, or time span of the meeting is today, but I have a number of questions, if the committee is okay with it, that I would love to start asking. Yeah, thank you, Director and others, for being here today. Appreciate your willingness to come share your perspective, and so that we can really get to the bottom of what's going on with the lack of enforcement in Jersey City, particularly around rent control. So I wanted to start to talk about the process in which rent control is enforced or not enforced, and namely around proactivity versus reactivity. So how is Chapter 260 being proactively enforced as opposed to just through tenant petitions only? And what kind of proactive enforcement work is the office performing beyond processing petitions, other than directing tenants to file petitions? What enforcement actions does the Office of Landlord Tenant Relations itself initiate under Chapter 260? And if there's any breakdown that can be provided among cases that are office initiated versus cases that are tenant initiated, that would be helpful. Any kind of data as to how many enforcement actions the office has initiated independently in the last 3 years, for instance, without a tenant petition. I know I have a few questions wrapped into that, so I'm going to stop.
Are you planning on, because we will issue some questions, so are we looking at the questions that were already issued? Because if we're going in that order, I'm prepared to answer.
Please.
Okay, thank you. Okay, I want to first begin by addressing any proactive measures. And actually before that, I would like to have it noted on the record that in these proceedings, it's already been seemingly predetermined that no enforcement has been taking place. I find that a little bit, and I spoke to Councilman Frank Gilmore, a little bit unfair, because it seems like that position has already been made before even one question was asked, to say that there's no enforcement. So I want to just, before addressing proactive measures, I think it's really important for this body to understand how the office operates and the scope of current enforcement that is taking place. The first thing I want to just put on the record is the role of the Office of Tenant Landlord Relations. Please understand that in the title, we are the Office of Tenant Landlord and not Tenant. And so we have to have a fair, we have to enforce this fairly for both tenants and landlords. Unfortunately, we are not allowed to be biased. So the Office of Tenant Landlord Relations administers and enforces the Rent Control Ordinance, Chapter 260 of the Jersey City Municipal Code, and provides education, information, and referrals to city residents in connection with landlord-tenant issues. The second thing, which I think is very important to understand, is that this enforcement is done primarily through clerical enforcement and registration oversight. The office's primary enforcement functions are administrative in nature, specifically receiving and reviewing landlord registration statements for all residential properties in Jersey City, not only those subject to rent control under Section 260-2. These registration statements are essential in determining the legal base rents for all rent control buildings and are critical in evaluating illegal rent increases and failure to maintain petition services. These petitions ensure that the tenants are informed of the necessary details to verify whether their current rent or any proposed rent increase is indeed lawful. Additionally, any landlord claiming exemption from 260 must provide supporting documentation to substantiate their claim. Finally, we have a complaint-driven enforcement approach. Similarly to how law enforcement relies upon reported activity to initiate investigation, the office relies on landlord registration and tenant complaints as the foundation of its enforcement process. Again, the office does not presume that a landlord is acting in bad faith without supporting evidence, just as we would not be here had the council not first received complaints. And I want to make it my final note, and thank you for allowing me. I've heard my name so much, so thank you for giving me a little bit of time to speak back. I want to also, as a point of reference, I believe that once we go through this tonight, you'll see that the Office of Landlord Tenant, as well as the Division of Housing Preservation, does not have an enforcement issue as much as it has an employment issue. When I first got to the office, there were at least 7 members of just the Landlord Tenant office alone. Over the last 3 years, for a substantial amount of time, we were down to 3 employees to cover the over 70, I believe somebody said 70,000 buildings or tenants rather in the city. So with that being said, I just want to make it clear that with a very short, underpaid and overworked staff, I believe we have done a substantial job to doing the best we can with the resources that we have. To your question, number one, how is Chapter 260 being enforced proactively rather than only through tenant petitions? The office proactively enforces 260 through receiving and reviewing landlord registrations, reviewing rent control exemption requests, and notifying tenants of their property rent control status. The second part of that question you asked me is what proactive enforcement work is the office performing beyond processing petitions? Publicly accessible rent control lists. This has been the goal for the past 3 years, and this is why enforcement efforts have been geared toward issuing summonses to landlords who fail to file their registration. Our enforcement efforts have proven effective as we have substantially increased the number of annual registrations on file, where when I first took the office, we were receiving approximately 900 annual landlord registration statements. Due to these summonses that we've been issuing, we have now received in 2025 approximately 1,500 landlord registrations. From a rent control exemption standpoint, I want to put this out there. Beginning in 2023, we began working with the Office of Construction Code to receive all newly issued certificates of occupancy. Once received, our office will contact the property owner to advise them of their registration requirement and to inform them that proof of compliance with the new construction exemption must be submitted to our office immediately if they wish to claim this such exemption. We also advise them that they must provide a written statement to all prospective tenants advising them of the property's rent control status. More recently, and in response to the mayor's executive order, the office has been mailing out notices to all of the tenants at a property to notify them that the property is subject to rent control and to the provisions of the rent control ordinance. The notice also provides our office contact information should they have any additional questions. And these are just a few of the things that we have tried to proactively do, as well as the things we've already been doing.
So you are saying now you have 3 employees and you.
So, yes, ma'am. I'm sorry.
No,
Okay.
please. I am just curious to learn.
So we just hired a 4th employee, but she's still in her probationary period. But for the last almost 2 years, we were down to 3 employees.
Then the number of cases went up 900 to 1,500.
Correct. And that's with a low staff.
Why is that? Just curious. to
Well,
know.
one of the reasons is because when I first got there, because of the COVID pandemic, we were not allowed to issue summonses. And so not long after my beginning my tenure, the mayor at the time gave us permission to start issuing summonses. So once we started issuing those summonses for failure to register, that's when our numbers increased.
So in 24, 25, you had 3 employees or 9 employees. Why the?
2025, ma'am?
Yes.
Yes. 2025, we were down to about 3. We just got the new one in the last.
When did you have 9 employees? What year?
No, I never had 9. When I first took the position, The previous director had about 7 employees.
Okay.
When I came in, we lost 1, 2, 3 immediately when I first came in. So we immediately were down to 4 because we had a part-time person who was a lawyer, and she was helping to issue petitions, do determinations. She left with the previous director. And then somebody else who actually, Ms. Jana, she was promoted to become the manager of the Office of Landlord Tenant. Thereby, the duties that she was doing, she couldn't do them at the same capacity because now she become the manager of the whole office. And so Jana's position, I didn't get somebody else. And then on top of that, there was another employee who transferred to the office of JCRA. And so she transferred about 2 months after me getting there. And again, she was not replaced at that time.
Thank you.
You're so welcome. And again, I apologize if I'm speaking too soon. I'm
Oh,
sorry.
you're perfect. Thank you.
I have some more questions and
Sure.
I want to let other committee members speak as well, but just to address what you said at the beginning, you know, I think from the first committee meeting that we all had, I don't think any one of us insinuated in any way that there is no enforcement happening of rent control, that it's down to 0 enforcement of rent control, Error 260, but it is very clear from constituent concerns and resident concerns from across the city, whether it's at city council meetings or through other just our
Absolutely.
emails that we get or phone calls, that residents are experiencing a lack of enforcement, whether it's of 260 or 218 or other codes in our city. And so these genuine concerns are motivating this committee's assignment here. And, you know, I appreciated the
No, I
conversation.
absolutely understand. And the only reason I referenced that is because I watched the first meeting and I actually spoke to the dignified, my friend, Councilman Frank Gilmore, and I heard it on record to be said that I'm going to let the cat out the bag, that there was 0 enforcement taking place. And so based on that particular statement to say that there was 0 enforcement taking place, I do understand, and we're here to collaborate because if things can be done better, but to start from the standpoint of saying that your office is not doing anything, to me, that puts us at a disadvantage when you're not coming to say, what are you guys doing? We're already accusing you that you're not doing anything. I think that's a totally different dialogue that we're trying to have today.
Yeah, and what we're trying to have today is to get to the bottom of where the gaps in enforcement are.
Absolutely.
So just to build on a little bit of what you're saying, it sounds like the proactive approach is less about looking for where maybe systemic violations are happening throughout the city, trying to go to buildings that fit certain kind of criteria for recurring cases or fit certain demographics in the city that there are recurring issues in, and more so sending out those kinds of notices to try and preempt issues. I'm curious about how you feel like those notices are being effective, whether you feel like they're being effective. Are they being tracked? Whether landlords are actually getting those notices to tenants? Is there any way of following up to make sure that tenants are receiving these notices, that they're understanding them, that they are, you know,
Right, understood. I actually, Jana, she asked me not to make her speak, but since she sent out the notices, I want to see if you want to add anything to that particular question. Yes, ma'am.
Good evening, council. So just to start, I do think just from our numbers, it's proven that our summonses have been effective. We issued over 913 summonses within the past 3 years for landlords who have failed to comply. And the way that our office enforces the rent control ordinance really is geared towards whether the property is subject to rent control or not. And without that information and without registrations on file, it's difficult to determine how we should be enforcing the rent control ordinance, per property. So we have taken, as Director Richardson said, a more proactive approach in trying to identify these properties. And that's really where our enforcement efforts have been geared. So we have seen a significant increase in the number of registrations that we have received on an annual basis. Like Director Richardson said, in the past 6 years, we went from receiving 900 registrations to 1,500 registrations. And so you can imagine if we're trying to track the rents that are in all those properties, if we were already understaffed at that time, we now are responsible for 900 more properties or at this point, 600 more properties. So it's just a matter of not that we don't want to enforce, because we are, right? Because the primary work flow of our office is the registrations. It tells us so much information, so that's really where our efforts have been geared, or getting those registrations into the office so we have contact information for landlords. So if we do need to mediate, we can, and getting the rents on file so that we could start identifying those illegal rent increases.
I appreciate that. I have a lot of questions about the registration list, but I want to allow some other committee members to jump in here.
Thank you, Director. Good evening. I wasn't at that first meeting, so I want you to know that I'm going into this hearing open-eyed and willing to listen without any preconceived notions. I do want to ask, though, I had requested at a prior council meeting of the BA's office that you issue a report to this council, and I was told you'd be issuing to this committee dealing directly with the port side violations and the status. Do you have a report to provide today?
So
If the question is there an update on the report? I do not have one. I'm happy to confer with the BA. Oh,
And just to be clear, my question is not the status of any litigation.
okay, thank you. I actually, I want to see if I can find the date. On February 4th, I actually sent this report to the council president, and from my understanding, she sent it to everybody else. In this report, it pretty much outlines, and so I can read, I've given it to you, but I'll read it for you because this is not connected to the litigation. Is that what you want?
Possibly, but let me backtrack. So what I do want to ask you is some basic foundational questions on process. So let's start there.
Sure.
And none of my questions are meant to confuse you. So if you don't understand, it means I asked it poorly. So feel free to ask me to repeat it.
Thank you.
What is the process for initiating a complaint that your office would receive? You said you're mostly complaint based the way law enforcement is. So take me through the process of a complaint being initiated with your office and go from there.
So we'll use this particular situation. I believe this would be okay. So a resident prior to my tenure, Portside reached out, possibly have reached out to the office, and they can call and say, I feel like this is the situation. I feel like my rent is illegal. At that time, we would make sure we do our due diligence to make sure that that property is indeed subject to rent control. If it's not subject to rent control, then there's not much we can do beyond that in terms of dictating their rent. Once that is said, we suggest that they an illegal rent petition. What that does is that it gives us a process of getting discovery from both the tenant and the landlord. In that particular case, the petition was issued. A determination was made in September, I believe it was 2022. After the determination is made, whether it's for or against the tenant, so if it's for the tenant or against the landlord, both parties have 15 days to appeal that determination. Once that determination is appealed, it goes to the Rent Leveling Board. At the time it goes to the Rent Leveling Board, it is no longer in our jurisdiction. Once the Rent Leveling Board looks at the determination, they can either approve it, deny it, or rescind it. In this particular case, the Rent Leveling Board, they sided with the tenant, whereas the first director, Diane Hendon, had sided with the landlord. After that determination is made, there's another 15-day appeal process that either party can have, and as you guys know, it goes into litigation. In that particular case, by the time I had gotten here, the tenants at that time had already been 60 days at least past their appeal process. The moment that I took the office, immediately what began to happen is I began to get harassed. I have members of my church here today. We were threatened by the tenants that they were going to come picket our service in order to make me rescind the determination. At that time, we told them that they were more than welcome to come to church as long as they would not turn this into something outside of a worship experience.
Right. I think we're getting outside of my question.
No problem. This is the report, so I'm just
I'm just asking specifically about Portside. My question was more basic than that. You get a complaint, there's an investigation done by your office, correct?
And so the investigation is based upon the petition, right? So once the petition is made, so let's say an illegal rent petition, we'll go through the process of you have to go through the landlord registrations. You have to go and see, you have to look at things like tenant turnover. You have to go to each month, depending on the month that the person was in there, the CPI changes per month. Once all of that information is compiled and you can make the determination whether or not the rent was illegal or it was legal. To us, it's just a determination. Once we make the determination, if it's now between the landlord and tenant, they have 30 days to reconcile that amongst themselves if they so choose.
Before it goes to the rent leveling board.
If they don't appeal. Now, if they don't appeal, it does not automatically go to the rent leveling board. It only goes to them in cases when it's appealed.
What about violations alleged at rent-controlled properties? Does that go to your office?
What are you talking? What type of violation? Can you be more specific, please?
An allegation, let's use, there's so many. Let's use security at a rent-controlled property with a certain number of units, right?
So security, that falls in, I believe, 254, and that would be more of a code compliance issue on security.
Okay, so on that particular issue, unrelated to your office, right? Okay, what about superintendent on site?
The superintendent on site, that would fall under our office. And so what we do, again, is we use the landlord registration statement, because within the landlord registration statement, they would have to show us that there's a superintendent, what unit they are in, what their contact information, all of that would be in the landlord registration statement. If we find, so if there's a complaint and we've had those complaints and we go back to the registration and on the registration, there's not proof that there's a superintendent there, we have issued summonses to that property for not having the superintendent on it.
Right, so that's when your investigation would indicate that a summons should be issued,
Absolutely,
correct?
yes.
Okay. And that summons is issued through the municipal prosecutor's office or through
No,
your office?
that particularly summons is issued through our office.
And who prosecutes that?
Superintendent. Sir?
That's prosecuted in the municipal court, correct?
Correct.
Okay, by our municipal prosecutor's
Yes,
office?
sir. Yes, sir.
Okay. What follow-up does your office do to determine whether, once a summons has been issued, that the alleged violation is abated by the landlord?
In terms of, once a summons is issued, that becomes for us the jurisdiction of the municipal prosecutor's office. We've not been in contact with them in terms of following up to see what happens after that.
Okay, so for example, there were, we heard the number was 913 summonses issued in the last 3
Absolutely.
years. Would you know how many of those resulted in guilty verdicts or pleas?
No, sir, not at all.
Would you know how many fines were collected by the city?
Sir, not at all. Not without speaking to the prosecutor's office.
Okay. When you, two more questions, I'm almost done. When your office issues the summons, the same way a police officer would be the leading witness, someone from your office would be the witness that gets a subpoena to attend to court, right? Or to
If
go
they
to
ask to come in, absolutely.
court. Okay.
That's if they ask us to come in. Sometimes they'll just ask for discovery, to ask us what do we use as a basis for the summons. They rarely ask us to actually testify. In the case like that, they could just look at the landlord registration, and sometimes that's enough discovery for them to say, based on what we have, we don't need you guys to testify. You've given us the paperwork.
Have you ever asked the municipal prosecutor's office to issue a report of how many summonses that you issued resulted in fines being collected by the city?
No, sir.
Of the 913 is a big number, right? It's a lot of work to be done. What I'm trying to find out, I think what this committee is trying to find out is what happens next. Does anyone have an update of how many cases actually were prosecuted successfully, meaning that there was a violation found and sustained in court?
I would believe in the same way that there are certain questions the municipal prosecutor can answer as it directs to me. I'm not in a position to answer those questions on behalf of the municipal prosecutor. We're more than willing to work with him if that becomes something that we're looking to do in the future. But then that is another added burden that you will be asking us to do when the office is already doing that.
Okay, so staying within your wheelhouse then.
Yes, sir.
How many times have your employees testified in municipal court in the last year?
I wouldn't know that off the top of my head, not in landlord tenant. Please understand my office. So you have the office, but we also deal with short-term rentals. We also deal with lead abatements. We also deal with lead inspections. We also deal with vacant properties. So landlord tenant is just one slither of what our office does. So as it relates to testifying, I would, top of my head, think maybe 20 times we may have had somebody, but none of it to me was landlord tenant related. A lot of it falls under short-term rentals.
Meaning violations issued to short-term
Absolutely.
rentals?
Yes,
When there were alleged illegal Airbnbs, for example?
absolutely. And anytime we're asked to come, we're more than willing to come.
Do you have a report on how many of those summonses issued to short-term rentals were resulted in fines being issued to the defendant?
No, not off the top of my head, and because that was not the reason for this meeting, if you just reach out to me, I can gladly get you those numbers.
Okay. Couple quick things, just following up if I
Yeah,
may,
Jay.
on Councilman Zupa. You mentioned that security was outside of the scope. Security is in 218, Article 1, uniform security service. Does that mean that you feel like that?
218, right?
So that is within the scope of?
No, not me. No, our practice has been for the security, but that 218, that's been the prosecutor or the Office of Code Compliance. I'm sorry, Code Compliance would handle that.
Okay, so your office is not doing any of the enforcement work
And-
on 218.
And just for background, before, at one point, Code Compliance and Division of Housing Preservation used to be one office, but they split. And once they split, then Code Compliance became its own entity, and they took basically all the inspectors with them.
Understood. And then on the note about superintendent disclosure, on October 23rd, 2025, landlord at Portside Towers pled guilty in municipal court to 71 superintendent disclosure violations at $2,000 per summons. January 8th, status conference, Assistant Prosecutor Vishnu Kamraj represented to the court that the landlord was in compliance based on information received from the Division of Housing Preservation, and clarified that Housing Preservation had confirmed that the landlord had notified the division of a superintendent. But there seems to be a discrepancy between the state DCA requirements of someone being on site and the actual municipal Chapter 260 requirements. So there is no superintendent at Portside Towers relevant to the Code 260 requirements. So I just would love to understand why did those 260 obligations go unenforced, as if the separate state level DCA posting requirements were sufficient, as opposed to that landlord meeting the more specific disclosure requirements under Chapter 260.
Did you answer that question again? I've been instructed not to answer that question specifically to Portside because they're in litigation. So can you make that more general, please?
Okay, more generally, is the office distinguishing between the requirements of the municipal level 260, the municipal level requirements under Chapter Code 260 for superintendent disclosure, and the state level DCA maintenance service provider requirements?
No, we're not. We are enforcing Chapter 260. We're not taking on the requirements of the DCA.
Okay, so my question is there a distinction that your office is making between those two?
Yes, we are. There's two separate distinct things.
Okay. All right. I do have questions about that specific case, but I guess I have to hold on to those now. I would like to follow up maybe outside of a public meeting. Is that possible, Corporation Counsel?
Certainly, and there will be a resolution on this coming city council meeting for a closed session where we can discuss the litigation, and it would be appropriate for Director Richardson to attend that closed session as well.
I appreciate that.
Okay, Chairman.
Oh, good. Okay, Rolando.
Yeah. So thank you, Mr. Chairman. Good afternoon.
Good afternoon, sir.
I want to begin by begin my statements by thanking Director Richardson and his staff for appearing before this committee. This committee, just to state this on the record, was established by a unanimous vote of this municipal council and was previously established by the previous municipal council. And because of as my colleagues have said, tenants across Jersey City have come to us with complaints about enforcement of our rent control ordinance, as well as other potential violations. And so we're basically have an obligation here to understand what is working and what isn't working.
Absolutely.
So I want to be clear about my approach today. I'm not here to prejudge you
Thank you, sir.
or your office. I'm here to get facts. The committee's job is to understand how the system functions, where the gaps are, and what this council needs to do legislatively, budgetarily, or structurally to make sure the laws we have passed are actually enforced. That tenants in the city have the right, not just on paper, but they have the right to see that enforced, right? Our job is to find out what those rights mean in practice. So I just want to follow up on what Councilman Zupa asked. with regard to the process
Yep.
and the process you undertake. Did you, after a court has judgment, makes a judgment on a tenant landlord complaint, is your office still involved with the activities post judgment?
It depends on what the judgment is. And so if the judgment from the higher court finds out that the landlord, they uphold and say I'm sorry, sir, that the rents are illegal, then we will uphold whatever their judgment is. Their judgment supersedes ours. And so we find out that they say that these tenants are still paying high rents, and that's their decision. Whether we agree with it or not, we will uphold their decisions. And so at that time, we will be willing to issue summonses to the landlord in saying that you are still in violation of issuing these high rents.
And do you have a sense of how the number of judgments that are found where the court has found the landlord in violation, and then your follow-up, and you mentioned 913 complaints
Correct.
In 1 year. So do you have a sense of how many of them have gone to court and ultimately our determination has been made, and then how many you followed up on?
So I don't have the totality of the numbers that go to court. I do have some cases that have come back to me where landlords and tenants have resolved their issues that have been based on our determination, or they're going against it. We record that because there have been times when a tenant has filed a petition and then he's gone to the landlord and said, well, listen, we went to court and we resolved it. So we'll take that court case, come back, and then amend the determination to reflect whatever the Superior Court says, because at that point, whatever their determination, it supersedes ours. But you're looking at maybe 10 times in the last year we've had a case like that.
So through this entire process, from the time that the complaint is filed to its resolution, and then the follow-up after court violations, or if it's found not guilty, does your office maintain a tracking system for complaints so that you can be able to verify which complaints are remaining open or not?
No, once it leaves my office, no, sir.
Do not maintain a tracking system?
We keep any determinations, anything that our office does, we keep a tracking system of what our office does. But if you're asking me, once it leaves our office, do we follow it to track what happened? The answer to that is no.
Do you have a system that's tracking that? It's a digital electronic system of some sort? It's a database, Excel spreadsheet?
So everything that we do have a database for everything that we do. We track it in our drive. So we do have a database for any determination that we make.
You have a database, you said?
Yes, sir.
So you could be able to tell us that database would have records about how many are open and how many complaints are still open?
In terms of petitions? Yes.
Yeah, okay. And you could tell us how, on average, how long they've been open?
Absolutely. That's one of the questions you guys have submitted to me. So yes, we can let you know that as well.
Okay. I'll defer to other council people and then
Sure.
I have other questions.
I guess, first, thank you, Director Richardson, for coming. This committee essentially have been tasked with trying to find how do we make good representation in city departments, making sure individuals adhere to city ordinance and or laws. So I guess the biggest issue for me is trying to have a system where there's multiple checks and balances.
Right.
And I'm hearing what I've been hearing, it's almost like these departments are operating in their own little silo, and it's essentially a disservice to everybody. Case in point, Councilman Gilmore's a bad landlord. He's been to court 120 times he have a rent control buildings, and he's not following almost none of the rules, right?
I've heard about that landlord.
And he's following almost none of the rules.
Right.
There has to be some form of system to say, hey, this is a habitual offender. We've had multiple citations come in about Councilman Gilmore. So at some office, there has to be some type of alert mechanism hit. So that way, residents and then also the council, we don't feel like we're powerless because for me, we're up here passing legislation to address issues as it relates to landlords not doing what they're supposed to be doing. And that's why for me, when I say there's no enforcement, when I'm speaking enforcement, I'm talking about the issuing of the citations, the following up with the citation, and then subsequently the consequence for said citations. So I guess my question for you in your office in particular, when walk me through the typical issuing of a violation for something at my rent control establishment. A tenant calls and say, hey, director, this landlord is doing X, Y, Z. It's rent control. What do you do?
In order to answer that question, I need to know what X, Y, Z. Give me X, Y.
All right, X can essentially be he's charging too much, right? He's supposed to have security at the door. Security is never there. Right? Specifically as it relates to the things your office handles.
Okay. So, again, and please keep in mind, so when we hear accusations, please be mindful that we still have to do our due diligence to find it out. So if a tenant says they're overcharging my rent, we have to have proof, not just accusation. And so a situation with that, the same thing we would do is that we find out the property is subject to rent control, because we have to find that out as well. And if I could just take a small little rabbit trail, I'm not trying to avoid the question. We do create task force. So like if there's a habitual landlord that we find that we just keep getting complaints. I don't know if the property was on Bergen Avenue. I think it was 412 to 418. I could have the numbers wrong. But we kept getting complaints about a property. I called you about that because I did a task force. So at that task force, you had my office, you had the fire department, you had code compliance. Once we find out a property is like that, we will go together to see what can be done. At that particular property, we found out that it was not subject to rent control. And so while code compliance could do some things, our office was not able to issue any violations because it was not subject to rent control. Because all the violations that we get, ultimately, is not just about the summons, it's about how are we controlling the rent. And so when we get the landlord registration, all of that discovery, it lets us determine whether the landlord has the right to raise that rent or not. It all goes back to rent control. So forget this, we talked about the security. So let's move, because the security is 218. Let me move this back. Can you hear me better?
Yes.
Okay, I'm sorry about that. So let's talk about the superintendent violation. So if we find out that a landlord does not have a superintendent on the premises, let's say for the year 2025, right? When we go back and now that tenant says they're raising my rent, and guess what? We don't have a superintendent. If we find out that they don't have a superintendent, we can deny the landlord the ability to raise that rent that year because that's part of the compliance piece. But in order to do that, we have to see, did he do his due diligence?
Now, right there in that instance, right?
Absolutely.
You say that you have the jurisdiction to deny him the rent increase, right?
Correct. Well, not so. When I say jurisdiction, let me just use my words clearly. To issue a determination. All we're doing is issuing a determination. We're saying our office has determined that this rent is illegal. So it's a determination.
So what if anything happens if your office in the rent leveling board deemed the increase not to be warranted and the landlord raised the rent anyway?
So that's where you have the situation where if that continues to happen, then that becomes more. So we can issue a violation to say, listen, the rent leveling board, and we've done that before, has determined that this rent is illegal. You cannot increase their rent. We can turn around based on the rent leveling board's determination, because now we're complying to what the rent leveling board said, and we can issue a violations or even a summons to say we have made the determination and we are remaking the determination and issuing a summons. But once the summons is issued, there's not anything more our office can do.
So once we issue the citation or the violation, the landlord in essence can continue to
Absolutely.
overcharge tenants.
Absolutely. We do, our office does not have a mechanism to literally make him stop. We can make a determination to say that this is illegal, and then you can go before the rent leveling board. But that's why, as you guys are suggesting, if there's a way to collaborate with the prosecutor's office, because if the fines are, so if you have a $2,000 a day fine and you're getting the max fine, then to me, that becomes a deterrent. But without that, you're absolutely right. All we can do is issue determinations. We do not have the power to stop a landlord from increasing rent. We can just issue summonses, we can issue violations, we can issue determinations, but our office does not have the power to legally make him stop.
Okay, few more questions, ladies. So as it relates to this landlord identity disclosure,
Yes.
you have to disclose who's the super, where this individual live at. But I believe there's two type of infractions. There's one for essentially not having a superintendent, and then there's one for not disclosing who said individual is, correct?
Yes, sir.
Okay, so as it relates, and I guess I don't want to keep beating a dead horse. If it was 900, there has to be a way to track, like, because we can't just say we've issued 912 summonses, right? All right, fine, 912 is good. How many have been adjudicated? How many guilty? How many plea bargains? Because that tells the picture of essentially one, if as a municipal government as a whole, if we're doing our job, right? You get pulled over and get 37 tickets and go to court and get found guilty of one.
Right.
But we're harping on the number of 37. So I guess at some point, we're going to have to tighten systems up. There has to be, again, some check and balance, like you have to follow back up. And in essence, it makes offices run more efficient, right? Because for your office to write a citation and for the citation to go to court, and your office is pretty much oblivious to what happened, right? Next time a complaint come in from said establishment, like you almost don't have no backgrounds because we don't know exactly what happened. Is that an accurate assessment?
Well, I would say this, and I'm on the record of saying it, and I mentioned it prior, when ordinances were added, my concern has always been, as you're writing the ordinance, are you making sure that the staff is there to be able to do what you're saying? Because if we're not staffed, if I'm telling you, so right now we have 4 people, and we're already behind in certain things, to tell us now to add another system that the prosecutor's doing to go follow up, we're going to keep getting behind if there's not a budget change that gives us the proper staff. We are more than willing. We want this to work. As you can see, my presence here, we want this to work for all the constituents. We're frustrated because what you guys don't hear are the constituents that we help. You don't hear the number of people that call us and commend us for how much service we give them, because they don't come here and they don't complain before. But it's not that it's not happening. And so I can go on record. I can say that there was a particular tenant who, once we were able to finally get to her petition, I was able to find that she was being overcharged $200 to $300 a month for 3 years. She thanked me, she appreciated me, but she did not have the time. And I'm not going to force people to call you to give me a pat on the back, because I'm going to do my job, whether or not I'm getting recognized or criticized. Because to me, it's about the job that's being done. But I'm telling you that there's a lot of constituents in this city that will also say they helped us tremendously. What I'm suggesting is that can we come up together with, number one, some budget issues? Because if at the end of the day, I'm saying, help me, I'm grossly understaffed, and the answer is no, but still do this, then you're putting us at a disadvantage. And I'm also willing to talk to the prosecutor's office to say, listen, what are some systems that we can put in place that won't overburden us, so that the council can say, listen, this is what they're doing, this is what we can give you? Because I never want you guys to not have an answer, because we're here to support you guys as well.
Okay, wait, let's go,
I said
You have, as they relate, okay, and then we'll let Elena and Mamsa.
Thank you. Just some follow-ups. Director, other than having residents call you to give you the praise your office deserves,
Sir?
what mechanism do you have to follow up on violations being abated? So we talked about the municipal prosecutor's office, right? That's on them, and I have a question about that in a second. But in terms of, okay, we've issued a summons, but we want to make sure this landlord's not still doing the same behavior. What mechanism do you have to make sure that abatement, that issue has been abated or solved?
So when you're talking about illegal rents, if we're saying the same thing. There's not a mechanism to follow them once they go to the court system. I'm open to find out, again, if it's a possible mechanism that can happen without handicapping our staff even more. But right now, once it leaves our office and it goes to the municipal prosecutor's office, we have not to this day had any mechanisms to track these summonses once they go to the court.
So the municipal prosecutor's job isn't to make sure the landlord changes its behavior. It's to
Correct.
Right. That would be your department.
Well, I mean, what do you mean to make?
So for example, you issue a summons, the municipal prosecutor prosecutes it.
Correct.
But in terms of the landlord failing to continue whatever bad behavior was exhibited, that would fall on your division, your department, correct?
Absolutely. And again, if you're talking about 70,000 tenants, are we going to now go chase down and find out what's going on with each tenant without them letting us know? Once we are told what's happening, we would absolutely issue more summonses, but keep in mind, it's another summons, which has not still made the landlord change his behavior if all we keep doing is issuing summonses and writing determinations.
All right. And Chairman, Mr. Chairman, I believe that the municipal prosecutor was noticed for this meeting today too?
No, not for today. Their meeting is separate, but I think
So
in light of.
yeah, I was gonna make a request, yeah.
We're gonna have to, at some point, we're gonna have to bring all entities in together.
My request to Corporation Counsel would be to ask the municipal prosecutor if there is a report of how many summonses in a given year are heard or prosecuted by our municipal prosecutor's office. What percentage of those are dismissed? What number of those are dismissed? What number of those are adjudicated one way or another? And I think it's very important that we have the municipal prosecutor and the acting municipal prosecutor's staff here to ask a lot of the questions which I've asked Director Richardson, who graciously gave me responses. But what we're hearing today is that from a prosecution standpoint, obviously that's not within his department's purview.
Yes. Lena,
Thank you. I had a follow-up question and then I had some procedural questions.
Sure.
You mentioned that your office can make determinations, right? And you can make a
Yes, ma'am.
determination if the, if the tenant is paying too much in rent because the landlord is charging too much in rent,
Correct.
et cetera. My understanding is that there's a certain mechanism for tenants to withhold rent. And it's very specific. They have to open an account, place the difference in escrow, and that process, my understanding is that they must receive a determination from your office and then the clock starts. And then after 30 days, they can begin withholding excess rent. What recourse do tenants have if they never receive a response or a determination?
So when it comes to them withholding their rent, we don't give them any type of legal advice such as that, right? That's not within our purview to tell them to withhold their rent. We've not heard anything in terms of they have to wait for a determination to withhold their rent. That's not something that I've heard before. And so when it comes to legal advice, we're not here to give them that type of legal advice. We do offer them documentation of numbers that they can call, but my office cannot give them legal advice.
Oh, yeah, I understand. I'm not asking for you to
Okay,
provide
just-
legal advice, but if
Yes,
they are seeking a determination and they believe that they are paying too much in rent or that their landlord is in violation and and they would like to begin withholding their rent because they've done the research on how to legally withhold rent. They're not seeking legal advice from you, but they are seeking a determination from you one way or the other. Is there a timeline in which you would give them a determination? What can they expect if they never hear anything? And do they have any, if they are waiting for a determination, you know, and yeah, just to
Yeah,
get the
I understand the question. So at this point, we've never been told that somebody needs a determination to withhold their rent. That has not come across me personally. I'm not saying it hasn't been done, but since I've been there, I've never heard, this is one of the first times me hearing that is a prerequisite to withholding your rent. As you guys have asked, yes, we are grossly behind when it comes to the timeline when we want to issue determinations. There's several factors why that is. I told you in the beginning, we don't have any, we just got one hearing officer who is solely focused on issuing determinations for failure to maintain service petitions, but she only works part-time. We just got her a year ago. So we would need at least 2 hearing officers. And if we had 2 hearing officers, my determination would be at least 30 days from the time they issue the petition to the time they get a resolution. Right now, we are grossly behind. In 2024, our office got locked up for 6 months because we were given the task that we had to do, and it stopped everything. So that put us behind. So right now, to be fair, we're telling people we always first come, first serve. Right now, unfortunately, I'm saying a year because I'm doing some of the determinations myself. But my goal is to get those determinations out as quick as possible. But we don't have anybody who's just that's what they're doing. So I'm trying to do what I can. Really, I'm the only person right now issuing illegal rent determinations. You're so welcome.
Sorry. I have some procedural questions as well. So the opening clause of Chapter 260, Chapter or Section 2F1 reaches every qualifying landlord, whether or not subject to the restrictions of rent increases. And so a landlord may assert an exception claim, or rent control status may be, you know, being litigated or otherwise unclear. Given that the code applies to every qualifying landlord, whether or not subject to the restrictions of rent increases, how do you interpret that language in your office's day-to-day proceedings?
I mean, in terms of landlord registrations, every landlord has to file a landlord registration. That's not just for landlords that are exempt from rent control. When it comes to rent control, those we literally enforce properties that are rent control, but there are some things, again, the landlord registration, 1 to 4 properties, which are definitely not subject to rent control, they still have to issue a registration, and we receive and review those registrations. And as of now, we do that free of charge, which that's something we're trying to change, because that's a heavy load on somebody. We're not getting any revenue for that.
Councilwoman, can I just piggyback on that? Is that landlord registration and rent registration?
No, landlord registration. So
Do you
the
handle rent
registration is
registration?
part of the landlord registration. It's within that.
The rent registration?
Yes, sir. So when people file a landlord registration, the rent registration is a part of that.
I apologize, Councilwoman.
No, that's fine. It would also be helpful to understand your document retention policy for tenant submissions, including how case files are preserved and how a tenant or even this committee could request an inventory of materials currently held.
Eric, you want to answer that? The document registration, retention?
Could you repeat the question?
Yes, it would be helpful to understand your document retention policy for tenant submissions, including how case files are preserved and how a tenant or this committee could request an inventory of materials currently held.
Okay, so basically we abide by the New Jersey State Retention Schedule. I believe I'd have to go and check it again, but I think a petition has 3 years of retention. We hold on to longer than that because, you know, in a lot of cases, even landlord applications are 3 years retention. And you're talking about a capital improvement application that is good for the following 10 years after it's approved. So if we destroy that, I mean, we'd have no record of it. So yeah, when it comes to petitions, we keep that on site for at least 6, right? Yeah, 6 years. Even though the state retention schedule says different.
Has your division ever received a subpoena for records? And if it has, what sort of timeline would it take to receive an index and produce documents?
So from my understanding, we have not received a subpoena for records, but I will go on record to say that even with the new council people that are here, I think we've been very, very cooperative to the records that you guys have requested from us, even without requiring an open request, because normally an open request is determined, but because you guys are the new council and we've been working really hard with you. So as you guys have seen, outside of just cases where we're overwhelmed, and I even put out a memo to you guys council in terms of your aides. And one of the memos I put out was to please ask your aides if at times they can reach out to my assistant, because as you can see, I'm a one-man band and I don't like getting behind. So I asked them to reach out to Eric because Eric can catch stuff that I might miss. But just as of now, we have no problem giving you any records that we actually have on file, but we have not been subpoenaed.
Following up on some of the earlier questions about, how you hand it off to the municipal prosecutor's office and then the case is sort of out of your hands and it's in the jurisdiction of the municipal prosecutor's office. Is there anything you see that this committee could assist with following up?
So what I would say is that I don't know what they do, so I've not had any bad experiences with the municipal prosecutor's office. I know that they themselves are understaffed. What I would ask is that I see that you guys are really concerned about that. And about 2 years ago, we actually had started to try to have monthly meetings with the prosecutor's office. I will go back to that, where I'll start out a monthly meeting so that way we can have dialogue without it having to always be on this level. And then I could give you a report. And then in those dialogues, once you talk to the prosecutor, again, I'll work with him on a monthly basis and then come up with some type of report that alleviates some of the confusion or just the feeling that nothing is happening, because they've been more than welcome. Anytime we ask for them, they work with us.
Director, quick question. So you spoke a little bit about we issue the violations. We can't essentially force them not to raise the rent. But I want to ask, what, if any, power does your office have as it relates to rent receiverships? Like, I know in the municipal code, it speaks of rent receiverships when individuals are essentially not following the rules and regulations, where the city will come in and we will essentially, by default, take control of the finances of said establishment.
Okay.
Because for me, this is what really hurts me, right? When in particular landlords, right? Because I know if someone get a ticket for doing something, I know that person is going to receive a penalty.
Right.
I know if someone's pulled over, I can see them 2 months from now and they'll be like, yeah, Coach Wu, they gave me a $500 fine or they suspended my life. Like, I know something happened. So I guess what I'm trying to figure out is like within your office, what, if any, power we have to really hold these people feet to the fire?
So one of the things I will suggest, and actually for the last 3 years with the previous council, we had dialogue about amending 260, because I think that there's too many loopholes in there. But one situation that rose up, and I think you guys are well of it, where the office was able to get some more, a result with some skin on it, right? So we put our teeth in it. There was a property 336 North New York Avenue, and somebody had just bought the property, from my understanding, and they had filed for a hardship, because you have the right, after I believe it's 10 months, you can file for a hardship once you buy the property.
9 months, yeah.
Is it 9 months?
9 months.
And so what happened was we got a plethora of complaints of a few tenants that were complaining that they were trying to push them out. At that time, we not only met with the tenants, we met with Jersey City together. And so when we met with the tenants, it was going before the rent leveling board. You have to understand, based on the ordinance, the way it's written, when it comes to a hardship, all they have to prove basically is the numbers. They have to show you that they are receiving a deficit. But in this particular case, because we had tenants who were complaining that they were harassing them and they were doing things to try to push them out. But it wasn't the harassment. It was the failure to maintain services, because there was one tenant who had been without water for several months. On the harassment side, we really, there was not much we could do in terms of issuing summonses for the harassment. But what I told the tenant, I said, listen, here's what I need you to do. Though we're behind on these failure to maintain tenant service petitions, because we've met with you and we see this as a collective, I'm going to do your petition myself. I'm going to put it at the front of the list, and I'm going to make sure that it's seen before it goes before the rent leveling board. With that determination, the rent leveling board looked at the whole situation and they denied their application for the hardship, which the tenants, not only did they get a rebate because the failure to maintain services proved that they had no heat and no water for those several months. And so we issued a rebate for that. The landlord was not allowed to, on top of that, get a hardship determination in its favor. So that's a special situation, but it goes to show that we exhaust all of our means that we can to try to come up with some recourse.
So we have, your office have no power as it relates to rent receivership.
No, we don't. No.
Wow. Okay, hold on. Let Mamsa go, because she didn't.
Pretty basic question.
Sure.
Thank you, Director Richards,
I'll take it.
for coming out, answering all the questions. I'm just curious to learn, with the mayor's executive order,
Absolutely.
you already have 900 to 1,500 cases. What is going to be your strategy to resolve as many cases as possible, as you might have
I hear.
2,500 soon? So
Yes, ma'am. So I'm glad you asked that. And though she asked me not to speak much, I have, Jonna is a star employee. As the manager of landlord tenant, she has come up with some amazing initiatives. And so I want her to spell out to you some things that she had already started working on prior to the mayor's executive order. So Dr. Jonna, would you please?
Sorry. Can you just repeat the question? I'm sorry about that.
no. Going forward, what would be your strategy to resolve these cases where we are not waiting for a year or 3 years? Because you might have a lot more cases now with the executive order. So just curious to learn the strategy going forward.
So I think that I can give a strategy based off of where we are now, right? With the resources that are readily accessible now. To clarify, the increase in cases that you're referring to, it's not illegal rent or failure to maintain service, it's registrations. So we went from receiving approximately 900 to now 1,500. Now, what that does is it does create an influx in petitions, because we now are looking at the registration statements and we're seeing that there's potential illegal increases. So as far as a strategy, it's only, we can review the registrations, we can reach out proactively, address the cases as they come, try and be forthcoming with the provisions of the ordinance and what's within our jurisdiction to address. But there really is no, overall strategy if we're not given the resources to address the influx of work that we've created for ourselves.
What are the resources you need?
I would definitely think additional staff, but I defer to director.
I actually have a flow chart that I can show you guys, and we've already determined what a full staff for us would look like. So once this is over, I can issue that and let you know how many staff members we would need in order to be at least fully funded. So if you give me till tomorrow, I can show you what we have, what we lack, and the positions, because there are several positions that in order to push this forward and to make it more effective, again, I keep saying the same thing, we need staff. And the more initiative you're adding and you're not adding staff, we're going to be right back here again.
Yeah, I think because it's practical and then it's reality. So I mean, I get it. You guys need more staff. But the reality is there's no money in the budget for more staff. So it's almost, I'm basically asking if and it's a crazy request that we just have to be able to do more with what we got, because I'm telling you now, you're gonna submit that list.
Can I say this, Councilman? We have cross-trained everybody in our staff because everybody we lost. So vacant properties. We had to put, Eric's had to stop what he's doing. He's working on that. We have inspectors. We have them working on stuff. Everybody on my staff is doing multiple jobs because they were not replaced. So it's just somebody has to say what we can't do, because otherwise you're setting us up for failure if we're telling you this is what we need and you say we're not going to give it to you. You can't. Okay, you can't tell me we're not, you proven. So I'll send you the flow chart, show you what we have, show what we're working with. If you see the flow chart that we tell you with this, and please keep in mind, we generate revenue. Every job we have, we generate revenue. So we are a revenue generating division. So it's not really going to cost the city because we generate revenue. But if we say we can show you this is how much revenue this person can generate, this is how much person person can generate, and you still say you still can have the person, at what point do we just say we're going to stop telling them to create something out of thin air?
Oh, so just so I understand, your bottom line position is basically is the things that this council and this committee is requesting, I can't do it because I don't have capacity to do it.
If that is the answer, if it's proven, again, I'm not making an accusation. Everything I'm saying, I'm trying to lay out to you. And if I'm laying out to you and showing you that this is what we've done, and there's another initiative we added. There's a See-Click-Fix request that wasn't there before I got there, where people can ask questions about rent control. That's something that wasn't added before. We're always looking to add more, but we want to be realistic because the pattern has been add more, take away staff. At some point, I don't understand why anybody reasonably would tell me give you more when I can show you I'm giving you as much as I can. Well, to me, we're giving more with less.
Doctor,
Let Jake and then Rolando.
just curious to learn, Director Richard, why am I calling doctor?
Don't take my title.
In my eyes, you are doctor. Director Richardson, don't you think more penalty, more revenue? And I want to say, did you consider idea of having interns in your office?
Yes, we have. We've actually reached out for interns. We absolutely have. So we're not opposed to that as well.
All right, so 336 New York Ave came up before. The landlord's petition there was processed in 4 months. When we see tenants petitions taking a year, sometimes 2 years. So I think this is an example of tenants' frustrations across Jersey City, that they feel, as you're saying, you're supposed to, as an office, treat tenants and landlords equally, but there is this clear power imbalance between tenants and landlords, and tenants are feeling incredibly frustrated across the city that their petitions are taking a longer time. The rebates to them are taking a longer time, and landlords are being delivered more timely services is the experience of tenants across Jersey City. So I wanted to get a sense from your office of why this is the case, that a landlord petition might be ready at a building with really egregious violations like 336 New York Avenue, but then you go to 35 Kensington, for example, a year and 7 months, tenants were waiting to have their petition filled.
Well, again, as I reiterate in 336, there were several meetings with Jersey City together with the tenant as well. And keep in mind, I did that determination. So I had to, anytime I have to put my hands in things that it's taking me out of things. So somebody's going lacking because I have to do somebody else's job. To me, again, when you go from having 3 hearing officers,
right,
to none, I don't have the answer for you. We moved that up because it was egregious. They were on television. It was egregious what was going on there.
It was.
In that case, we moved it up. But if we move up every one, now you're back to the place where everybody's late.
Okay, so I think, again, this is a question of prioritization. Eric wants to answer? Thank you.
So pursuant to the ordinance, the reason why that moved so quickly is because we actually had to wait the 2 months for all of the required documentation. That's what usually holds up a landlord hardship application or any landlord application for increase in rent. Once we have that, pursuant to the ordinance, because I'm the hearing officer, I have 2 months to get in a hearing officer's hearing with the tenants. Then after that, draft within 5 days a recommendation to the board, and then get it to the board within 60 days. That is not a requirement in anywhere else in the ordinance, especially like for petitions. But if you look at 260-10, you'll find that there. Now, why that failed was because, yeah, there were open violations. There were so many issues with that property. I don't know if I can get into that on the record, but I mean, there were issues. And part of qualifying for a rent increase, 260-3G, is that you have a full building inspection prior to the application, and that that building is in substantial compliance. And that building was not in substantial compliance. There was health, there was hazardous issues there. And in that case, my recommendation goes to the board to deny it, and then the board makes their determination.
Okay, I appreciate that.
Yeah, I'd like to also add something, just for perspective. As far as hardship applications, we received maybe 5. How many have we received in the past year? 5 in comparison to 100+ petitions, right? And with the petition process, we're hearing from both the landlord and the tenant. So the documents are completely different than the specific documents that are required with the hardship application. So there's a difference in the process. It's not just a matter of addressing the petition in the order that it's received, but it's about what we're actually reviewing to either approve the application and or find that a reimbursement's owed to the tenant.
Okay, I appreciate that. And this is bringing to light that there is a required timeline for dealing with something like a hardship application, but no required timeline for dealing with petitions that come in from tenants. And I think that's a legislative issue that we should, as a council, address as soon as possible, understanding staffing constraints at the office. But this is also raising questions for me about harassment in Code 260, the harassment clauses in Code 260. So what steps does the office take to enforce harassment sections?
Have that written down. So if you look at Code 267B, it specifically deals with the fact that this is under the jurisdiction of the municipal prosecutor. Because again, so the discovery that's required is something that the prosecutor, our stance has been, that's been something that the prosecutor will handle versus us as it relates to harassment. The thing that we deal with more than anything will be failure to maintain services, whereas when somebody may deny a person heat as harassment, but because that's the service that's required, we can handle that under the failure to maintain service issue versus just a blanket harassment issue.
Okay, so there is no coordination between the Office of Landlord Tenant and Municipal Prosecutor's Office in dealing with the harassment?
No.
Okay, so when 995 Summit Avenue reached out to the Landlord Tenant Office about continuous harassment, retaliation by landlord and management, what were the actions of the office in that case?
We reached out, we talked to the tenant, and this was last year. We have email documentation to say that we suggested for their particular situation that they would do what we asked 336 New York Avenue to do, file a failure to maintain service petition. As of today, no petition was filed at all from 995.
No failure to maintain.
No failure to maintain service. We have the email where we suggested it, but they never followed up. And we reached out to them, I believe, more than one time.
And did you advise to go through the municipal prosecutor to make sure that the harassment charges could be attended to?
I'm not sure we advised that. I'm not sure. We primarily, when we saw that we could do the failure to maintain service, that was let us do that for you.
Okay.
We've not received that. So,
but yeah, they explicitly came to you with questions of harassment, concerns of harassment and retaliation. And so it's not the practice of the office to refer them to the relevant office?
Yeah. Again, that was over a year ago. I have to look at the email, but I'm sure that we always refer and we always give any documentation of any type of other help that we believe that they could get.
Okay. I also want to go back to 260-9. You were suggesting, I think, that the mechanism to remedy violations that the office has is summons, correct? To bringing appropriate legal charges to summons. And Also in 260-9, under the purview of the office, there's adjusting rentals and ordering rebates. So I just want to get a sense of the practice of the office. It sounded before like you can issue citations, you can issue summons, but are those other practices of adjusting rentals and ordering rebates also being carried out by the office?
They are.
Tenant? Okay, just earlier during some of the questions, it sounded like the only thing that
But it's within the determination. So please keep that in mind. So within the determination, we'll determine that this is the rebate that is owed. So the determination will have the numbers that we believe the tenant is owed in a situation where a tenant is owed.
and a determination only follows a summons and a citation, or no?
No, determination, it depends on the situation. So if it's an illegal rent situation, there's no summons that would be issued first. It would be the petition first. If the process is petition, determination, if appealed, rent leveling board, if appealed, it goes to the Superior Court. Once it goes above there and the determination is made, so let's say it stops at the rent leveling board and it's never appealed, and if we find out that, and we get word that they're still raising rents, we could then issue a summons to say, now the rent leveling board made this determination, we stand with them, and because you did not abide by them, we're going to issue summonses for this tenant.
And does the office have records of the kind of rebates and adjustments that have been made in the?
Any determination, those numbers are in the determination.
Okay, is there a record that the office keeps as to the history of the adjustments? And
No, I mean, the record itself is the determination. So if you file something and we said that you would, this would the determination had the numbers of what you're owed, that's on record. So that is the record of saying we have this and we keep this in the file.
Right, so if we were curious about the kind of total adjustments that have been made due to landlord-tenant issues in the last, let's say, 5 years, we would need to go through each single determination. There's no record that the office holds.
No.
Okay. Lastly, I just want to address.
Can I just ask a clarifying question to what you just said?
Please.
Sorry. So you're saying that the summons in and of itself functions as the rebate?
No. So again, whether in the other in a legal writ petition or failure to maintain service petition, within the determination, we will put the number that the tenant should, what the legal rent is. So at that point, we'll say, this is what our determination, let's just say you're paying $2,000 a month. And after we do our due diligence, we find out that the landlord did not do what they should have done, and you should only be paying $1,750 a month. That will be in the determination. The final determination will be from the office that our determination is that the tenant is, for these X amount of years, was overpaying. And now it's between the landlord and the tenant. They have, I believe, 30 days to rectify that between them two. But our determination is a legal document that says the office sees that the tenant was overpaying. And I don't like continue to always say the tenant, because there are times when the landlord is correct too. And so either way, the determination has the numbers, it has details, it lets you know why we came in with this determination, to let you know what the number or the rebate should be.
Oh, and then subsequently, the tenant and the landlord have the ability to negotiate.
Absolutely.
So you guys basically are saying the infraction in itself, it spells out what that amount is. Now, if
Absolutely.
you guys want to negotiate,
Absolutely.
fine.
Absolutely. And that happens quite a bit. A lot of times the tenant and the landlord will come to an agreement, and they will use the determination as to say, listen, we're going to do X, Y, and Z. So that happens a lot, that there are a lot of situations where they will come to an agreement amongst themselves before or after the determination.
Thank you. Sorry, Councilor, I interrupted.
That's fine. I just wanted to also ask about staffing, since staffing seems and employment seems to be the main issue in the office around successful enforcement of the law in an expedient manner. And also, this seems like the recurring theme throughout a lot of Jersey City's departments. I understand that you are not alone in this. How do you direct staff in triaging the caseload that you all have? What factors go into prioritizing some cases over others? What kind of staffing levels do you think you would need to deal with the current caseload as well? And also, when we talk about proactivity, do you feel like a proactive approach to systemic issues that we see throughout Jersey City's landlord-tenant relations would be more efficient than reacting to individual tenant petitions one at a time?
I mean, I believe, again, and I'm not gonna move from that. As of right now, I can tell you, I would probably need at least 6 staff members in order for us to run efficiently.
Under housing and preservation or landlord tenant?
So under landlord tenant, at least 4. So housing preservation, I would, to be honest, but I know you're not going to give it to me. So I would need about 8 people altogether. 6.
Listen,
I know
I
you
want to
can't-
give landlord tenant as many staff as we need to successfully do
Listen,
this.
since we're on
I
the-
want to understand the
since
process
we're-
of triaging with what we have
So
now.
since we're here on the hot seat, I would say why not use this to staff an office that you're getting so many complaints from, because we're getting them too. As I said before, we have cross-staff trained everybody as much as we can without suffering.
I guess I understand.
Sure, okay.
We want to staff the office. We want to staff all these offices.
Now-
Under the current circumstances, what is the process of triaging the caseload that we have? How do we prioritize the caseload that is coming in right now?
So to be fair, and remember, we have to be fair. It's first come, first serve. So they're specific. So like, I'm glad we brought back up 336 because the caveat to that is that it was a hardship. The hardship, because the hardship had a time limit on it, it gave us the ability to circumvent that, to go above the case. But normally, again, it's the first come, first serve, because at what point do you tell the last person that came in that they're not as important as the first person? So we try to get this on a case-by-case basis. As a matter of fact, even if you gave me the staff that I needed so that I could just not have to do everybody else's job plus mine, when I'm doing petitions by myself, at one point I was able to crank out at least 2 a week. But now that I have a million other things that I'm trying to do, even this today, there's preparation to come and make sure we give you proper answers. Well, all of this preparation for this day or so, it pulled me away from doing tenant petitions, because the tenant petition, because it's so much to it, it's hard to do that and multitask. That's one of those things, because it's a legal document and then lawyers are reading this. So you have to really take the time to make sure you're doing it, and being distracted, one mistake, they're going to hold it against you. So when I'm doing petitions, I have to be locked in my room. Do not disturb me. As long as I'm being disturbed, I have to start from scratch, because you can imagine going through 30 pieces of documentation for one petition. If you get thrown off of that for a day or two, you have to start from scratch. And so because I don't have the staff to at least just free myself, if I was free enough, I could promise you that I could do at least 2 petitions a week. I'm sorry, I am a doctor, but I'm not that good. I could do at least 2 petitions a week, but that's what continues to happen, because in the course of a day, we don't believe in letting a constituent leave out, because we do walk-ins, and we probably average about 20 walk-ins a day. And when the walk-in comes in, if a staff member is not able to facilitate them, I'll do it myself, or the assistant director will, because we're not going to send somebody away without giving them assistance. Not every office does walk-ins, on top of the fact that everybody in the office is required to pick up the phone. Sometimes, even if it's not your particular case, you'll give as much information as you can and push them off to somebody else. So we do a large number of constituent just conversations on top of the petition, on top of the walk-ins.
Understood. And I guess this brings me back to just like thinking systematically about it all and what's the most efficient way to deal with.
Hey, can you wrap up, Sullivan?
Okay. Yeah, just last thing I'll ask right now. If a tenant reports that a landlord, for instance, is renovating multiple vacant units in a rent-controlled building, raising those rents above legal limits, does the Office of Landlord Tenant, in this kind of hypothetical, investigate that conduct even if the reporting tenant does not occupy those specific units? I'm thinking, how do we proactively address this so that we can most efficiently deal with the large caseload that you have? Does that question make sense?
It sort of does, but the one caveat you said, if a tenant is not occupying the unit, are you saying that you want them to be able to file a petition or make a complaint on behalf of a unit that they're not occupying?
There is a large caseload of work that each tenant has to deal with in their own lives, right? And so if there's a tenant in a building who wants to speak on behalf of their fellow tenants, making sure that they're empowered to be able to do so and bring to you a petition that includes multiple units, multiple issues in a single building seems like a helpful way to the office to be able to.
But actually, it wouldn't, because at the end of the day, we still have to get information and documentation from that tenant in the unit. Now, I understand the situation if you have an elderly person and you're helping them, but the petition has to become from the person occupying the unit.
Okay, so we could have a petition that just has a neighbor sign off on.
Well, I wouldn't even say sign off. It would, again, if you're in a situation where a person physically, for whatever reason, is unable to do it, but you can't do it on behalf of another tenant, that tenant, the person who occupies that unit, because they're going to have to file a petition for themselves.
Okay, yeah.
All right, Jake. In the interest of time, we'll move on. Let Rolando ask questions. It's already 6:30, so we want to be cognizant of time, overtime, and all of that stuff.
Okay. So I just want to go back to something else that was said
Sure, absolutely.
a long time ago already at this point. Had to do with rent registrations.
Yeah.
Okay. So your office is responsible for rent registrations. It's part of the landlord registration.
Absolutely. Yes, sir.
So can you tell this committee how many rents are registered currently today?
How many rents?
Yeah, how many landlord rent registrations do we currently have today?
Oh. So as we said, as of last, so if we stay on point, because the registration period ends at March 3rd. As of last year, I don't know what the time, you know the, right? 1216. Thank you. That's why you're here.
1,268?
1,216 is what we received thus far this year.
This year.
alone?
This year.
So they register annually.
Annually. This is an annual registration. Yes, sir.
Okay.
That's the mechanism that absolutely gives us the power to issue summonses.
Correct.
This is an annual registration.
Right. So when they don't register and somebody comes with a complaint,
Okay.
Is there a determination at that point that because they have not registered, that it is then, I mean, what determination do you make, or do you give them an opportunity to cure their rent register?
So our practice has been, so let's say you come in this year and you say, my rent is illegal. Our practice in finalizing what the legal rent has been is we go back 6 years. So we'll look at the rent registrations for the last 6 years and look at the increases every year. So let's say 2021, they increased by 4%, but we go back to that month and find out that the CPI was only 8%. That's going to be within our final calculation. So every year for the last 6 years, we will see did they file a registration for one, and if they didn't, that year when it's time for the increase, they get 0 increase for any year they've not registered. So we practice going back a 6-year process, which is actually in favor of the tenant. If the landlord this year has not filed a registration, they've already lost the ability to increase for this year. But to know what the increase should be, we have to go back to the prior year.
Right. So if they haven't registered their rents, they're in violation of the.
They are in violation.
And what's the penalty for a violation of that nature?
Well, the initial violation is if they haven't, is the summons. So if they've not registered, the first violation, once it comes on our radar, is we issue them a summons for not registering.
You issue a summons. There's no fine. There's no.
No, remember, the fine comes after the summons is what triggers the fine. So there is no fine. The summons says, municipal prosecutor, they've not registered this year. So there's no fine attached to that and to outside from our office.
And then it's after the municipal prosecutor has to take that person to court
Absolutely.
for not
They have
registering
to
their
go-
rent.
They get a summons to go to court for non-registration.
And that's the law.
That's the law. Yes, sir.
Okay. And what are the rent registrations in previous years? Today we're at 1,268. What were the rent registrations in previous years? Do you have those numbers?
So we started out with 900 and they've gone up incrementally each year. And like we said, last year, we reached up to 1,500. We believe we're going to pass that because even though the registration cutoff period is March 3rd, once we go through the registration and we can go back to the rents that we've already had from the previous year, we can start issuing summonses for anybody who's not registered this year. So we should at least get that 1,500 and hopefully more. Well, not hopefully, we want the landlord to do right.
And we have, I heard you cite a number of 70,000 tenants.
Well, I cite that because that's what was said at the council meeting, and I believe it wasn't that 70%. I'm sorry, Terry. I said 70,000.
70%, yeah.
70% of the city. That's a
Renters.
low number. It's way more than 70,000. 70% of the city are tenants. I'm sorry.
70% are the city, a city of almost 300,000
300,000 people. Yes, sir. And you have 4 people in the office of landlord tenant.
Yeah. And do you think that 1,500 rent registrations is a good outcome for us?
At this point, from where we are, I think it's an amazing outcome when you see that we've increased. We have been, again, I'm mindful to let you know what we're thinking, but we don't want to be held accountable to what we're wanting to do if we're not given the ability to do it. What Dr. John didn't tell you is that we have been talking about creating a system where we are forcing landlords to prove that their rent exempt status, right? We're talking about that now. How can we put landlords in a situation where we almost put them in the category of being rent control until they prove that they are rent exempt? But when you talk about what it would take to even start to do that, I think it would be a great initiative. We're in the process of trying to figure out how to do that. But again, I'm very mindful because what I'm hearing from the council is that at the end of the day, we can't promise you staff. So if you can't promise us staff, please don't ask us to promise you more when we're doing more with less. I think that's fair.
So
Councilman, just a question following up on that.
Please.
So for the rent control penalty, do you increase the second penalty amount and third
No.
penalty?
Not for registrations, no. There's no increase. There's no penalty, there's a summons. So there's no penalty connected to that as it relates to our office. We issue a summons, and then from there, the prosecutor determines what the penalty is.
So I guess for legal, from a legislative perspective, can we do like motor vehicle do? They give you a date to register, to re-register, and if you don't do it, your kid could be in the hospital. There's a fee associated with it. There's no process of going to court. There's none of that.
If I can interject, one of the ordinance resolutions that we actually had started working on was late fees. So we've just not been able to put that before you as of yet, but we've actually already started working on register. And we actually, Jonna has done some research to saw what Newark is doing because they do have late fees. So that's one of the things that we
Okay, so we
want to
can,
introduce to you guys. Absolutely.
so we can do something.
We can't do late fees. Yes, but you have to pass it. We're going to present it, but you have to pass it.
Yeah.
Well, we gonna do our job to make sure, so let's let Rolando, finish up.
do you collect those, the prosecutor, you issue a summons, the prosecutor prosecutes it. And then who collects the fine?
It goes to the city. It doesn't come to us.
And your office is not responsible at all
No,
for ensuring that they pay their fines?
No, not at all, sir.
Okay. So earlier you also said that your office generates revenue.
Yes.
So what is,
So the
since you're saying you don't collect those fines of any sort,
Right.
what's the revenue that you're generating?
Well, absolutely. So good, Dr. John, we talked about that.
Sorry, so for registrations, right now it's $10 per unit for all properties that are 5 or more units. For vacancy capital improvement applications, it's $125 per application. For capital improvements, how much is it for capital improvements? Each application process that we have, there's a different fee for it. But like Director Richardson said, there is an ordinance, and I don't know how much information I could provide about that, that's pending in ICOMPAS that suggests an increase to some of these fees that we're imposing. Alone, our registration statements bring in over $500,000 a year. The last time that those fees were amended were in 2012. So we're looking to increase those fees to help supplement the costs of getting staff to come in to help facilitate those registration statements.
Okay, now, Director, when you say, so I get it. So in essence, your office, I mean, you're generating the revenue because one, according to what the doctor is saying, there's fees associated with applications and renewal, but subsequently by default, when you issue citations and stuff, money does come through the municipal government, it just don't go directly to you guys' office. Am I understanding that correctly?
Yes, and just to add, if a landlord doesn't register by March 4th, they're already not in compliance with the registration requirement, right? Unfortunately, if we are looking to address all of the non-compliant landlords all at once, our database for issuing summonses does not allow us to do that. We have to go in and manually enter each citation for each property. So a way to hold landlords accountable for collecting illegal rents because the rent roll is not on file with our office. We've proposed to impose delinquent registration fees as well on so that we could supplement the revenue needed.
Say that again, you lost me.
We impose that we should be collecting delinquent registration fees because as of March 4th, the registration is late. And so we should be able to impose a delinquent registration fee because the landlord didn't register within the time that they're supposed to. And so with the registration statement in connection to what Councilman Navarro said, the registration requires that a rent roll is attached. And this ordinance specifies that if a rent roll is not provided, then they're not entitled to the increase. And so a way to hold landlords accountable would be to give them a delinquent registration fee until they come into compliance with our office. So where we can't issue a summons because it's just not feasible to issue 800 summonses instantaneously, we will hold the landlord accountable to a certain extent at some point in time, so long as we get that registration statement in the office.
So help me understand, you're saying that these documents have to be in by March 4th, I think you said, right?
Yeah, March 3rd is the deadline. So as of March 4th, they're delinquent. And so just based on the number that Councilman Rolando asked, so we said we currently have 1,216 registrations, which means that 284 are already delinquent based on the number we got last year.
From last year.
Right. So if we issue just $100 per unit, that's already over $28,000 just because they're delinquent. That's just a light number. So that's already generating revenue if that was in place, because as of now, all of those properties that are not in compliance, we will be receiving fees from.
I think part of the issue is that it's only $100 and nobody really cares.
Well, I mean, that's light. We can go higher. That's just get some numbers.
Okay. Now, Director, what position you said that you need three, you had three of them and you only got one. What position was that again?
That's a hearing officer. That's somebody who's solely dedicated to do nothing but do determinations for petitions that come in, the failure to maintain service petitions, as well as the illegal rent petitions. Right now, we have a part-time person that's solely doing failure to maintain service petitions, but we have nobody who's doing the illegal rent petition, and the person doing it is part-time, which means that we're only getting them 2.5 days a week.
So, I mean, so what's the state standard? Is that like, can we operate in that type of a deficit?
I'm not sure, sir. We have been, but I'm not sure what the state standard.
Yeah, I think, Erica, we could write that down. That's something I
What's
definitely
the
want.
salary, Director, for part-time and full-time hearing officer?
I think the full-time hearing officer, if I'm not mistaken, I think it was roughly around $60,000 to $68,000 for a full-time hearing officer. Because the background that they had, we were looking for some type of legal background, because that would help them in making the determinations.
So I have a question.
And just on record, you know.
Hold on,
Sorry.
Can I put this on record? You know.
Yeah, go ahead, and then we'll let Rolando finish up.
We're
Yeah.
hiring people at $40,000 to $41,000.
Say that again?
You know, we are hiring new hires. I'm coming in at $40,000 to $41,000. So to me, that salary alone is egregious.
You're talking about part-time?
No, that's a full-time staff.
Oh, you're saying that's what the individual you're hiring is coming in at
$40,000 a year.
Well, I mean, that's a whole nother conversation. That's a whole nother conversation right there.
We don't touch salary question.
Yes. Go ahead, Rolando.
Director, so I'll stay on the topic of staffing.
Sure.
And so when did you come to this, recognize that you were understaffed?
My first year, because in the first year, the staffing started.
What year was that?
2023.
2023.
So when I first came in, I was already unstaffed because I lost 3 people before I even had my first day.
Okay. And so prior to this administration.
Yes, sir.
Did you submit a formal budget request for additional staff?
Every year.
Okay. Can you share that? You put that in writing?
Yes, sir. Yes, sir. I have it in writing, so I can share that with all the council members. Absolutely.
Okay. I'd like to see those requests.
Yes, sir. I will look.
Do those requests go to the administration? To your director?
They went to the director, they got approved we came to the budget hearings, but there was no, so so a few things happened. Remember, I lost 1, 2, 3 out the gate, and then within a year, somebody transferred. And so they transferred to another department. It took me almost a year to replace that person. And then when I finally got a couple of staff members, layoffs happened, and go figure, I lost the 2 people that I just got. So, and then we've added on staff, but we told you when we were here before, we had other initiatives. So when we had the lead inspection initiative, we were able to add some staff, but we had a grant for that. So the staff that we added was per grant. Now we have the lead abatement. And so we didn't add staff, we just changed positions, but we use grant money for that. But when it comes to every year, I've said that I need staffing. I have that and I'll send it to you.
Okay, appreciate that. And then we talked about tracking and databases and
Yes, sir.
things of that nature. You make a determination, it goes to a summons, et cetera, court. But prior to going to court, after court, you don't really have anything to do with that
No, sir.
violation. But prior to that, it's in your wheelhouse.
Well, it's in my wheelhouse until it goes to the rent leveling board, because if I make a determination and it's appealed, once it goes to the rent leveling board, it's no longer in my wheelhouse.
Okay. And then when the determination is made and you're tracking this, right? So you have some system that's tracking it and you say, rent was registered as this, and this is in violation of your rent because it violates the rent control laws for Jersey City. Then you have it tracked somewhere that says that those rents were in violation.
Right. The determination itself is a tracking system because we keep copies of the determination. So if you ask me, if you came to me and we issued the determination, you can always come back to me and then I could look at what's going on since then. But again, that's only if it's not gone to the rent leveling board, because at that point, it's whatever they decide, it's their jurisdiction. They made the final decision. And sometimes they can override my decision. They have that authority. So our tracking system is just, we keep the record of the determination. So the determinations I made, I can pull up the file and I still have records of them.
So can you provide us a summary report of how many determinations where rent was deemed to be illegal or improper or in violation of the law, and on an annual basis since your time here?
Could you please repeat that again? I want to make sure I'm clear. How many?
I'd like a report of your determinations where rent was determined illegal.
Yes, sir. Okay.
And if you have that information, also the amount that was deemed.
Absolutely. That would be within the determination. Absolutely.
Okay.
Yes, sir.
Yeah. I just have a question with regard to a specific situation, and it's no hidden secret. This has come to this council and the previous council because of the situation and the residents who brought it from Portside Towers. And so how many determinations, well, let me start this. The rent leveling board determined that they were in violation. Is that accurate? I just want to make sure my facts are correct.
Yes, the rent leveling board determined that they deemed both properties to be subject to rent control. That was the rent leveling board's determination.
And they were determined to be in violation of that determination?
No, so
Of the rent leveling board determination?
So what the determination was that Dinah made a determination that both properties were not subject to rent control. Once it went back to the rent leveling board on appeal, their determination was that they believed that both properties were subject to rent control. So that was their determination.
Right. Then what's your role and your office's role after the rent leveling board determines that they're in violation of the?
Well, the role would be is if it's appealed, then it goes to Superior Court or Federal Court. So that would be the procedural role, is that you would go to the next step.
The tenant would.
The tenant and the landlord, because
Yeah.
if one appeals.
What's your role inside of that? It's my question. After
role-
that after the rent leveling board made its determination,
Uh-huh.
what's your office's role in enforcing that determination of the rent leveling board?
If it hasn't, are you talking, if it has been appealed or has not been appealed? Because if it's been appealed,
Regardless of whatever the situation, if you want to give me one situation and then the other, that's fine.
okay. So in the, again, in the case, if it's appealed and it's in litigation, it is beyond my jurisdiction. If the rent leveling board, so in a situation where they say, okay, this property is subject to rent control and it's not appealed, at that point forward, if they continue to raise the rents, we have the ability to issue summonses per the rent leveling board's determination. So it's not, at that point, it's not per my determination. It's per the rent leveling board's determination, but we do have the power to now begin issuing summonses to align with the rent leveling board.
So in those cases,
Yes, sir.
You issue summonses when they are not, when there's no appeal in that regard, or
Well, we would, so again, so because as we've talked, we don't track them, but if you are that tenant and you reach out to us and say, listen, they raised my rent again, we need discovery. So what I would need is a copy of the lease that shows that they raised the rent, because I just can't go by accusation, and then I need proof of payment. So once
talking about the original complaint.
Yes, sir.
So it's determined that the rent leveling board determines that they're in violation,
Correct.
and then it's not going to appeals, it's not going to court. What's your, you say you issue, what's your role again? Please state
To
that.
issue summonses to align with the rent leveling board.
In alignment with the rent leveling board's decision. Okay, and that summons, then what does that summons require of the landlord?
Well, the summons would say based upon, again, we would need, the only situation we've had is that we would still need discovery to say that, okay, they raised my rents.
No, this has already been determined by the
Okay,
rent
so,
leveling board to be in
well,
violation.
In the same situation, then we've had a situation, again, without going, I'm watching what I can say, where we've gone back, because now we have to determine what are the legal base rents. So we would have to now, so if the rent leveling board says the rents are illegal, then somebody has to determine what are the legal base rents. We had a situation where we went back 6 years to determine what the legal base rents are. Once we have that information, then we can issue a determination to say that this is what this tenant should be paying. And if you don't do that, summonses can be issued. But we still have to do the discovery because we got to figure out what is the legal rent.
To determine what the amount is.
Yes, sir.
So we'll go through that step then. You determine what those rents are, you determine the 6 years, look back, all that stuff, and then you discover that there's X amount of dollars that is due back to the tenant, right? And you issue a determination, is that what it's called?
Issue a summons.
A summons.
Yes, sir.
And do you track those summonses?
No, sir.
Do not.
No, we do not track those summonses. No, sir.
Okay. So, but you have physical records of those summonses?
Yes, absolutely.
So I'm going to ask, and it's going to be onerous, and I know your office is taxed and overworked.
Nope, I leave now. I'm quitting right now, man. Go ahead, Axel.
I'm going to ask for some numbers.
Okay.
Let me just say for 2025,
Okay.
how many of those summonses finally came to a conclusion,
Yep.
and you issued that in alignment with the rent leveling board decision and after doing your due diligence to
Absolutely.
make the determination? I'd like to know what those numbers are just for the year
Okay.
2025.
No problem. Sounds great.
Okay.
Yes, sir.
So, Director, staying along those lines, let's say you guys made a determination, it was appealed, it went to the rent leveling board. The rent leveling board said, you know what? These dwellings are rent control.
Right.
Subsequently, the landlord, he's going to appeal, but regardless, and help me, correct me if I'm wrong, regardless of what the landlord is appealing, your office position is to uphold what the rent leveling board determined, correct?
Well, so here's what I would say today, right? We would uphold the rent leveling board's determination, but ultimately we operate under the fact that it's been appealed and it's going to be the Superior Court is in process of making a determination that's going to be final, which also puts us in a situation that no matter what we do, we're going to be subject to the Superior Court. And so we have to be mindful of the resources we give or something that can be overturned. And that's happened to us. And we can't get those 6 months back that we put in effort that led to nothing. So we do, and to me, it's like any other situation. We've had conversation to where, and if I could just be very frank, right? In most situations, when people, regardless of what the infraction is, when the process has to go to litigation, whether you agree that it has to go there or not, you have to wait for a determination. It's not a situation where you're fighting for something, you're fighting at the court, but yet you're still telling this people, do this, do this, do this, do this, do this. We work as much as we can, but we also are mindful that since it's something has gone above the rent leveling board, it's out of our jurisdiction. In those situations, can we issue summonses? We can issue summonses, but understand also that it's still just a summons. So we are not opposed to issuing summonses, but the practice has been to follow protocol that once it goes above the rent leveling board, because it's outside of our jurisdiction, we would normally not begin to get involved in something that's still in litigation.
What if
Okay.
there are other violations that are not under
Absolutely.
litigation at the same property? Could you then issue?
Absolutely. Yeah, because then that's not connected to that. Absolutely.
Yes, and also in that, when you're looking at the chapter, the violations speak to per unit per day.
Correct.
Okay, now have your office ever embarked in that journey as it relates to violations?
Well, from my understanding, that was amended under the last administration so that one violation carries that summons per unit per day.
So if you issue it on January 1st and
It's
it's not
abated.
rectified by
Absolutely.
default, it automatically,
By default, it incurs that fine daily until it's abated so that we no longer have to issue a summons each day in order to get the same result.
go ahead, Jake. Oh, Lena, you would,
I had a question circling back to different topics. So if your topic is germane, then you
Mine
could
was
go
the
first.
Control building.
Oh,
Yeah,
yeah, so is mine. So you go first and.
Okay, appreciate it. Yeah, I wanted to know how many rent control buildings exist in Jersey City, where official records are maintained.
Okay, so as of right now, approximately 1,400 is what we have, but we're still working on that list.
1,400?
Yes.
1,400 rent control buildings, and how many units would that be?
It's hard to tell.
That could vary widely, so we would have to get
Each
back
unit
to that.
makes
Because remember, in
more units than the other.
one unit can have 300 properties. It only requires 5 or more, so that could be a very wide list.
Right, so we have a general sense of how many buildings, but no sense of how many units.
No, not at this time.
Okay.
Not on top of my head, or D.
Hold on, yeah,
So we are working on getting a publicly accessible list. The list that we are adding to, we are including the block and lot as well as the unit information. So once we get through that list, we will be able to tell you the total unit count.
now
Okay.
just speak to real quick, how do units, not all units that's 5 or more are subject to rent control. If you can speak a little to how one dwelling becomes under rent control.
Or so just from how we're in practice right now, we have, the way that we're compiling the list is we're taking all of the properties that are classified under 4C on the tax plate, which is essentially apartment units. And so what we're doing is we use that as a basis plus our registration inventory to determine exactly what properties would be subject to rent control. All 5 or more unit properties are presumed to be subject to rent control unless they have one of the exemptions. And so our office is actively working towards identifying all of those properties that we either have an exemption on file for, or we need to follow up with the property owner to get that exemption on file. And just from how we've been doing that, we'll go on Tyler. If there's contact information, we'll reach out to the landlord. We'll send an enforcement notice requesting that the landlord provide certain documents depending on the basis of exemption that they're claiming. And we're issuing approval letters that detail the proofs that were reviewed by our office to determine that the property was subject to rent control. So all of the properties that we have in our registry, we're looking at what the landlords indicated as being subject to rent control or not. Those are being added. So it's just taking a bunch of different sources for one complete list. But ultimately following up on those properties that they've been operating as exempt and or we believe that they qualify for an exemption, we're actively trying to get those proofs of exemption on file.
And all 1,400 units that are under rent control is responsible for submitting rent, for rent registration every year.
Whether the property is subject to rent control or not, it has to submit a registration every year as well as a rent roll that lists the tenant's rents as well as the base monthly rents.
And how
The
many
tenant's
have we
information.
received today?
From January 1st to March 3rd of this registration period so far, we're at 1,200. I've issued approximately 50 summonses so far just this year for failure to register. We hope to get, the 1,600 that we should be receiving registrations for, but that'll, be additional enforcement.
Now, hold on, Lane, as it relates to those violations that you've just issued, are any of those dwellings habitual offenders, if you know?
Off the top of my head, I don't know, but I have an Excel sheet where I compare the ones I submitted, I issued this year to previous years. So I probably could identify repeat offenders.
Yes, if you can give this committee access to that, because that's part of the problem we're tasked with finding a solution is seeing. I mean, it seems like, the council against all landlords. No, we're against bad landlords.
Yeah, and just to provide some perspective with that, when I'm issuing a summons, if we have contact information on file and we see that a landlord registers every year, we will call them, we'll send them an email. We don't just result to issuing a summons. The summonses are issued when we see those repeat offenders or we don't have registrations on file for several years. So we are mindful because the landlord's either going to be responsive or not. And we do have a lot of landlords that are responsive that we could pick up the phone and get them to register. So the summons is the last resort.
All right, thank you. Yeah, Elena.
Thank you. My question is, my understanding is that a landlord is delinquent and they are not complying with the registration. They are not complying with the rent rolls. They are not registered, that they then are not allowed to increase rent until they are in compliance. So it seems to me that telling a landlord they're not allowed to raise rent would be perhaps a more impactful way of bringing them into compliance than the summons. Is that something that you've looked into?
I think just in response to the mayor's executive order, we definitely feel more empowered to take a proactive approach. So as we've been seeing these instances, we do send notices directly to the tenant, telling them that the property is subject to rent control. We provide the CPI increase so they're aware of the allowable increases. And we also provide them with the 18 causes for eviction to ensure that they're not experiencing unlawful eviction practices. And as far as notifying the landlord, we basically tell them that you have to come into compliance. If you don't come into compliance, then we're going to notify your tenants that you haven't complied. And, hopefully at that point, if there are landlords that are non-compliant, we can get them in a position where they're willing to comply.
I also had a follow-up question, Director Richardson, what you were saying earlier about how if the case is in litigation, then, you're just completely hands off after that point. My question is, does this not overly place the burden on the tenant? Because it would seem to me that if there has been no injunction or no stay issued by a court, a higher court, even if it is being appealed, that it would seem that for the time being, the rent leveling board's decision should stand.
So as I said before, I mean, we have done that. We have issued, again, summonses. If it comes to our attention so once the rent leveling board makes that determination, there is no way around getting the information we need from the tenant. There's no way around that. They have to let us know, and then they have to provide us the documentation so that we can make an unbiased decision. We have no problem doing that. Again, and if there's infractions that are not connected to that, I have no problem issuing summonses as well. But there is no scenario where the tenant is not involved because we are relying solely on documentation that are given to us. We just can't be proactive. We have been and I hope you can hear that we have been working to be as proactive as we can be. but we always have to take the stance that we need the documentation. And as John has just said, we are working on things where we have bad actors, because we agree, Councilman Gilmore, we're trying to go after bad actors. But at the same time, even while you're trying to go after bad actors, we have to do our due diligence to make sure that we are doing something fair. We're not the Office of Right to Tenant Counsel. I know that was something that was supposed to be done. We don't know why that hasn't been done, but it sounds like what you're asking is already an office that's just not in existence. We have it, we just don't have a director. But that would be more somebody who would be a tenant advocate. We're not a tenant advocate, we're landlord tenant. To me, that's what it sounds like.
That's not what I was asking.
Okay, well then clarify, please.
Sorry if I was unclear.
Okay.
Very clear.
So, after the rent leveling board issues a decision, right? And if the landlord does not like that decision, the landlord then appeals.
Correct.
You said earlier that at that point, your office is hands off during the length of the appeal. And it seems to me that all a landlord would need to do would be to tie this up in appeals indefinitely, and the tenant can still get no relief. So my question is, if it's being appealed, but there's been no injunction or no stay issued by a higher court, then why does the rent leveling board's decision not stand? And why can further summonses not be issued?
I'm going to answer this question because it touches on active litigation. Ultimately, what may be true from a policy perspective once something is in litigation is irrelevant. And what matters most is what the judge says. I will share publicly what I have shared with the council this weekend, which is that since coming into my role, I have asked for updates from the litigators who have been litigating this case. They have reported to me under all of their ethical duties, including their duties of candor as attorneys, that at the outset of litigation, there was a verbal instruction from a judge to not issue any unfair rent increase tickets. Now, my perspective coming into this role is that something that may or may not have been said years ago is not a strong enough basis for me to advise the city, my client, how to act. So I have directed the team that is litigating the case to seek from the judge a written order clarifying exactly what the city may or may not do. Because at the end of the day, every party to the litigation deserves certainty about what is appropriate and not. But ultimately, the answer to your question, Councilperson Little, is once the matter is in litigation, it is entirely up to the judge.
Thank you. Thank you for the clarification.
And does, if I can follow up on that, does each individual case is determined by each individual judge's decision? Like, could they have different decisions on how to treat that situation?
Yes, federal judges can pretty much do what they like. They can administer their cases how they see fit. Unless there is binding precedent that governs a particular situation, it is up to the discretion of a judge to decide what they think is prudent. One judge could say that I think it is prudent, pending appeal, for the status quo to be preserved. Could certainly make policy arguments about whether or not that is fair, but that would absolutely be within the judge's right. Unless there is binding precedent, a different judge could come to a different conclusion.
So, Sarah, I just want to make sure I'm understanding this correctly. Once it's in the jurisdiction of the court, basically the work that we're doing to find out the terminations as it relates to the amounts and rents, none of that matters because of the court's determination?
It would not be in the city's interest to violate a directive from a judge that is presiding over one of their cases.
Let me ask another question with regard to this. How many of these cases go to federal court? More than 5?
I would have to check, so I don't even want to give you a ballpark number, but that's the number that I could check. I'm not sure off the top of my head.
And you have records of that? If they go to court? Not that
The law department will.
if a court case that's not involving us, it's between the tenant and the landlord, you would keep that record? Is it,
If a landlord is appealing a determination by the rent leveling board. The rent leveling board would typically be a party in that suit, in which case we would absolutely be able to pull records of those litigations. And to be clear, what I'm referring to is litigations that are either in New Jersey Superior Court or in federal court. We're talking about something that is completely different from the municipal court process.
Okay, I would love to see those numbers because we're talking about this as though it's like every case is going to New Jersey Superior Court or federal court, and it's stymieing us and tying our hands and handcuffing us. And, you know, I know we're only talking about, it sounds like we're talking about one particular situation, and we're talking about kind of just the general like enforcement of rent control for residents throughout Jersey City, right? So.
Yeah, Jake.
Yeah, I just wanted to return to the rent control buildings. It seems as though, I mean, we have these cases where a historically rent controlled building is chopped up into LLCs, where a building of maybe 30 units gets chopped up into a group of many 1 to 4 unit quote unquote buildings that then get out from under rent control. And that loophole is killing rent control stock throughout Jersey City. And it seems like it would make your jobs a whole lot easier if we could cut that loophole and get to avoid the questions of determinations of rent control in these cases. I mean, could you speak to whether it would make your job easier if City Council were able to cut that loophole and actually bring under rent control any of these condos that are within historically rent controlled buildings that otherwise would
Oh,
qualify?
I'm gonna let Eric, he's my LLC guy.
So I would love if you excluded or exempt condominium buildings from rent control. That would make it easier for sure, because you can start out as an LLC, a corporate entity, right? You can have 5 or more units in a building, start selling them off. You're increasing rents, we're following up, we're writing determinations, we're answering petitions. And then, yeah, next year or that year, you sell off a couple of units. Now you're no longer under rent control. So now you're rent control exempt. It is very difficult to track. It's very difficult to issue summonses in that case and enforce rent control. If you could just give me that question one more time.
Yeah, I guess my question was the opposite of including those kinds of properties in Code 260 to make sure that, let's say, historically rent controlled building has 5 or more units past the 30-year window of being exempt. Classically rent controlled building, those units get bought up by various LLCs to be under that 5-unit threshold and are now condos out from under the jurisdiction of 260. My question is, wouldn't it make your jobs much easier in terms of enforcement if we were able to bring those units under 260 regardless of their status as condominiums?
I would say no, but I'll leave that to the manager of Office of Landlord Tenant Relations to answer. I think that would be, I mean, it's burdenous already with the amount of properties that we have. You know, we're talking about 1,000 whatever, you know, properties, and we're not talking about units. You know, some units, yeah,
are occupying it. Maybe we can talk more offline about this, but John, I mean, if you have any perspective here, I'd be curious.
She definitely does.
Just that it definitely is difficult to track. I think it's a bigger issue, right? Because we have landlords, we have LLCs, and it's the same care of for the LLCs. And that's really what we're trying to avoid is the entity or the individual owner of that LLC. So yes, it's definitely difficult to track for us. I agree that just saying that the property in its entirety is subject to rent control indefinitely. But I don't know the laws around a property undergoing a condo conversion and then selling off the units individually and what that new owner might have in their relationship with the tenant to get them out of that unit. You know, at that point, I think that's just additional conversation at that point, because that tenant that was there that would have been protected because they were there when it was a 5 or more unit property subject to rent control. Once they leave, is the unit now subject to rent control or is it not? I think it's just additional conversation we'd have to get, advice from the law department on.
Okay.
And in the case of a condo conversion, we'll accept the application and forward it to the state. But also we will send out notice for protected tenancy. So those that are disabled or elderly, we will review their cases to make sure that they keep their rent controlled unit. But I believe, and I'd have to check again, I think it's 3 years notice if you are a property owner that is going to convert your rental property into a condominium property. I believe so.
That's right.
Yeah. Okay. Any other questions?
Chairman.
Follow up?
Yep, I just have some information requests before this committee comes to a conclusion. So at every step in this process, in terms of where your office is involved, whether it's issuing summonses or determinations, complaints coming in, I just want to see summary data over your period from 2023 at every step of the way. I'm gonna have to rewatch kind of this is being recorded, correct?
Yes.
Yes.
I'm gonna have to rewatch it to just understand where exactly the touch points were. But from the time that the complaint comes in to the time in which you make a
Yes, sir.
issue a determination, summons, and then ultimately referral to whether it be the rent leveling board, if you have numbers about that, referrals to the prosecutor's office, et cetera. If I can get data about that on an annual basis, that'd be great.
So I have one request. If it's possible for any request you make, if you could send me an email of that, because that way I can be very, very strategic and specific.
Sure, I can do that.
Thank you, sir.
Yes. And Rolanda, if you can just put the whole committee
Yeah, absolutely.
on the email and as well as Corporation Council.
Yeah, I just have one other question, which is, we talked about it going to the prosecutor's office. It's kind of out of your hands in that regard. I just want to know what sort of, over your time and period, what sort of interdepartmental kind of coordination have you had with the municipal prosecutor when determinations have been made that require them to enforce the law around that? What is the mechanism and how is that referred to them? What's the communication around that with that office?
So that particular, the communication we've had with the prosecutor's office has primarily been around short-term rentals. When it comes to this process, these are not conversations that the prosecutor and I have had concerning this particular issue. I'm open to talk to them to see about doing something moving forward, but most of our conversation with the prosecutor's office has been primarily focused around the issues of short-term rental properties.
Around what?
Short-term rental properties.
So when you do what's the mechanism? What's the form in which a violation that ultimately has to be referred to the prosecutor's office? How does it get over there? Is it just?
I issue a summons. So once the summons is issued, it automatically goes to the prosecutor's office.
And that's the extent of it. There's just like
Yes, sir.
a carbon copy triplicate sent over there.
Absolutely.
Okay, gotcha.
And it's always been like that.
It's always been like that.
I mean, I just think, I don't know, man, I just think it has to be, and I don't know from what side or whatever, it just has to be more cohesion, because if you guys don't operate in unison, you can essentially effectively do your job, and subsequently the prosecutor office can effectively do their job.
Again, I want to say that everybody's understaffed. At no point are we not willing to do what we can do, but I also, until I talk to the prosecutor to know what his burdens are, I'm willing to have that conversation and then to come up with what we don't want to do. And I want to say, we want to be realistic and we want to be as collaborative as possible, but I can't make any determinations without first speaking to the prosecutor's office. You have my commitment to do all that I can with what I have. And if you want more, give me more and we'll give you more.
If I may make another question. What in the past year, I'm not talking about, I'm glad to hear the expression moving of collaboration and interest in moving forward. But we're also talking about past here right now, right? So
Absolutely.
trying to understand what's
Absolutely.
going on. So when you has anyone ever said to you from former administration, department director, anyone said to you, you know what, this is really a problem. Like you really need to go talk to the prosecutor about this and see that we get something, that he's aware of these violations, that we need to be able to enforce these.
The only thing I know in terms of that, I remember that there was a time where the prosecutor and myself were here and we spoke to the council, and at that time he began to explain to them some of the things that were going on. But outside of that, there's been no directive, if you will, to talk to the prosecutor. Again, that's been a personal decision that we made when we were able to make it. So that comes personally from something that, again, and I take in these things as well. So walking away from here today, for me, one of the things on my list is what can I do to help forward this while talking to the prosecutor myself. So I'm very, very, intuitive to hear what you guys are saying and to find some realistic ways, what can we do? So I will be reaching out to the prosecutor and reporting to you what we look.
Also, I think this committee is tasked with making recommendations, and I know that's going to be part of the recommendation we make to the administration. I can't overemphasize, there just has to be cohesion amongst all of the departments, whether you're talking about construction code compliance, quality of life, the prosecutor's office, landlord, tenant, there has to be cohesion, man. And I'm of the opinion that being that you guys are also understaffed, that's even more of a reason to be collaborative, right? Because it puts everybody at a disadvantage if we're not using everything at our disposal. And again, it's not a direct knock on you per se, it's a knock on a system, the situation, right? And that's what has to be, we just have to find out, how do we rectify that?
What I, again, reiterate is before we move forward, that's why I want to talk to the prosecutor, but you guys have the power to do that. Because I really feel like whoever the prosecutor is, they should be able to let you know what they're facing as well, so that they can see what they're going through. And I think once that's done, we can come up with something more cohesive when we know what everybody's shortfalls are, what they can do better. I think the cohesiveness is to talk about what everybody's facing and how can we work together. But until that happens, I think we're going to keep coming here. But I want you to know again, council, that committee, that and I can speak, I've not had any other department that we've tried to reach out to that's ever been adverse to it. So from my experience, I think that you'd be surprised how frustrated the directors are, because we want some help too, and we're willing to help each other. So I don't think that at any point we're against you. We're not against the constituents. We're trying to figure out, and that's why I came tonight, because I'm actually thankful for the invitation, because I wanted to come, and the council people that I've already talked to, I want to say it's been very, very pleasant. It's been very, very pleasant. I did have a nickname for you, Councilman Jake, but I'm not going to do that because I don't know if you would like it or not, and I don't want to get in trouble.
You can say it on the record. That's okay.
Well, I call you Councilman Kenny G. I call you Councilman Kenny G.
Believe me, I've gotten it before.
Okay. But I will say I am looking forward, Councilman Rolando, all of you guys. This was pleasant to me. Glad to I do feel like we're looking to work together, and we want we all are working for the constituents. That's how I see it. And whatever we can do to help the constituents get the answers that they need, because it hurts me when somebody calls my office and the property's not subject to rent control. Yes, I'll give them the resources, but at the end of the day, some of these 1 to 4 units, you think the rent control properties having problems. These non-rent control properties, the rents that they're paying for these 1 to 4 units with slum landlords, and we can't do anything for them, that breaks my heart. So I hate turning anybody away without doing whatever we can. And I know even at one point, Councilman Joyce Wadman, she even mentioned some things about the 1 to 4 units, because there's a large group of people in the city who the only answer we can give them is here's some paperwork. But it breaks my heart that we can't do a failure to maintain service for those guys. So I'm all for but I just want to make sure that we don't give empty promises. So that's why I'm just, and I'm on the record, guys. I've come here several times to say, guys, I hear what you're trying to pass, but if we're not having conversation first, sometimes you're making decisions without talking to the people to enforce them, and then saying, why didn't you enforce them? And we're saying, why didn't you ask us? We want to work together. We want to, I promise you, I'm very happy to be here, and we're happy to do whatever we can to make this work. I want you guys to have a great first term. I want it to be something you look back and say, we got some things done. We're here to work together.
I have one more question.
Yeah, Rolando.
I asked if there were any, if you were given any directives to.
Yes, sir. Yes, sir.
Things. I'm going to do the inverse of that question. Were there any directives not to take action, or not to, don't go after that one too vigorously, don't go after that one too aggressively?
So I would say we've actually, the only directive we've gotten was to aggressively to come up with some legal based rents. That was a directive that we got from the administration to get this done. So that was the only thing we got. And in that particular stance, it was actually almost going after the land.
When was that given?
That was given in 2024. And that's when we locked up our office for 6 months to do the legal base rent unit for a particular property. And that directive, when I say directive, it was very much understood that the administrator wanted to get that done. And they even gave us extra bodies during those months to try to get that done. So that's the only directive I've ever gotten from the administration.
Yes, I recall that, and I would just say what came of all of that hard work should be enforced. So I guess, we essentially have our marching orders as it relates to, what we're hearing. We're hearing about lapse in systems. We're hearing about, all of us needing to be on the same page to deliver a fair and justifiable outcome. So does anybody have any further questions, comments, or concerns?
Very brief.
Yeah,
I promise.
No,
just is there a sense of an estimated date of completion for the list of rent controlled buildings and units? 2 months.
We're shooting for 2 months.
Wonderful news. Okay.
It's 2 months?
Yes.
No, but as it relates to the number of units and the number of people who've registered thus far, we can get that relatively quickly from your database, correct?
You're saying how many people submitted registrations for the 2020?
No. It was, you spoke to the fact of issuing 50 some odd citations. So what this committee want to look at, if you have a record of just the last 3 or 4 years of the violations and or the entities for said violations, if we can have access to that.
Yep. So long as there's no problem legally, I have that in.
I don't think
yeah.
legal have
Yep.
she's shaking her head. No, she don't have
I have it in an Excel sheet each year, so everything that was issued just in reference to 260 as well as 20A, I can get that to you. 260-F and 260-20A.
Okay. Well, I do want to thank all of you ladies and gentlemen for coming today. Hold on, go ahead, Director.
This is my last comment. If you were going to keep us here this long, I think as the the president of this committee, there should have been pizza for everybody.
There's
We
just
have
believe that to be
deficit.
the case.
Director,
There
don't
is-
forget, we have deficit.
Okay,
No.
we have a deficit.
No, well,
Yeah.
there is food in the restaurant across the street, so you're more than welcome to go to the restaurant.
And don't
But,
forget that I gave you nickname too.
Okay, appreciate it.
Yes.
That's all.
But in
Thank you.
all
Thank you very much.
seriousness, I do want to take this time to thank everyone who came out today. You know, the objective of this committee is not to try to harm anyone. We're essentially trying to find reasonable solutions for real people to address the inequities we feel we have in this city. So with that being said, can I get a motion to close?
Motion.
Wait, do we have our next date?
I heard,
For the-
Councilwoman Elena,
The dates are set. It's
2 weeks, every 2 weeks, isn't it?
no, it's monthly, right?
Please.
Yes, the dates are already set. They're preset.
Do we have our May date?
So we actually set this
Oh,
date.
this date,
Right.
okay. So why
We
don't
didn't
we,
set the rest of the year because I think we was a little undetermined on what specific day that you guys were going to.
today's Monday, right?
Yes.
Monday the 13th. So we'll go Monday, this looks like, what is this, the second month? This is the second Monday. Council's our first Monday, right? All right, so we're every second Monday.
May 11th, Monday,
So-
May 11th? Is that-
Yeah, that would be
Yes,
May 11th for
whenever-
the next meeting.
Whenever it is.
I got it. May 11th. Same bat time, same bat channel, right?
Yes.
Now I'm showing my age.
And I just want to caution the committee that we have to, there's earmarks in the ordinance as it relates to, us submitting something, perform a recommendation. So if we're going to, look to call in other entities, we need to do that, iron that out. Because we have to get everybody before us to get their sworn testimony or get their perspective of what's going on. And then subsequently, at some point, we're going to have to, I would imagine, bring in all of them together. So we'll figure out who we call in next, and then subsequently we'll go on, and then we'll have all of them together. Then we can generate the next report. So that way we're at least looking at trying to have some real progress.
Chairman, do we know who the next individual is that you're going to
I
bring?
think, is it the prosecutor's office?
Yeah, I think.
Yes, May 11th, if we can, the prosecutor's office. I know they're busy. Is that enough time for them?
I would
to,
ask.
Clear their schedule. SAC Corporation Council. May 11th.
I'm happy to pass along the request if you'd like them to appear on May 11th.
Yes, please.
I suspect.
I'd like the
they will
former
be looking to
prosecutor
apply,
to
but
be,
You want,
Like the
So-
acting. chief
so
municipal-
if you want we're gonna have to subpoena the former prosecutor,
or just request him, and then if he declines the request, then
and we'll subpoena.
she was subpoena.
Okay,
For May 11th?
Yes.
Interested in the former municipal prosecutor or the current acting chief?
Former chief prosecutor.
we want
My understanding is that the current acting as well as some other municipal prosecutors have ideas on how to make the office better. So would it be possible to invite them all, or would that be too much of a
no, I think we should invite them all.
Invite them all.
current and former?
Yes.
Time.
Okay, so
Great.
you would like
The
me to
3 hour hearing.
invite all current municipal prosecutors and
No. The chief prosecutor, the former and the current, who's the temporarily placeholder right now?
Commissioner Kemrosh.
that's
Him and
Jake Hudness.
and Jake
Hudnut,
Hudnut.
those
Two
two,
of them.
yes.
In Corporation
Yes.
Council, you mentioned to me that there were others who had approached you with ideas of how to improve the
Yeah,
municipal
but I
prosecutor's
think
office. So
for the sake of trying to get answers, I mean, they can come too.
Yeah,
The
yeah,
most
they can come
important thing is to get the ones that can give us the answers. And then, like Director Richardson brought his supporting staff who have ideas, they'll
Yeah,
get the same.
okay,
ones. Yes.
okay, so extend the invite to.
Yes.
others.
Okay, I will invite them both and invite them to extend the invitation
Yes.
to any other designees who they think would be, whose contributions would be productive. If you would like to subpoena someone, there is no guarantee of a date certain by which we will be able to serve them or follow the formalities that are necessary with the subpoena. So I will extend the informal invitation and apprise the council, and we can take.
All right, so in light of all that, If we can send the request for him to come tomorrow to May 11th, if he don't respond within 72 hours, then we'll issue a subpoena.
It will take longer than that to prepare a subpoena. We'll have to have a meeting and talk.
Oh, no, we can start the process. However, I mean, I don't know the legal parameters of how long, but at least at that point, he will have answered back or not answered back.
I'm sorry, we should also include the Office of Code Enforcement Director, both present and past. I don't know if it's changed over time, but
Office of Code Compliance, Director Joe Barrow.
I mean, whoever is enforcing, was it Chapter 218?
Gentlemen, can we do this offline with the Corporation Council? Would that be
I
possible?
just want to get on the record that we're doing.
Yeah. We can, I mean, I'm happy to have a further discussion, but I actually have a neighborhood association meeting that I'm speaking at.
Okay.
We just needed to know who we're inviting so I can
Yeah,
include
yeah.
them on the email that when they send out the notice.
Yes. Do we have everything? Is the everybody
we do.
good?
So let's do that motion again. I'm going to ask for a motion at 7:41 PM to
Motion.
close.
Motion.
Second,
Motion made by Councilperson Efro, seconded by Councilperson Lavaro. All council members present by acclamation, please say aye.
Aye.
We are out of here at 7:41 PM. Thank you so much, everyone present and everyone watching at home. Remember, teamwork makes the dream work. Have a great night. Stay safe, everyone.